First case we're going to hear this morning is Walker versus City of Charlotte. And I guess, Mr. Perry, are you the first one up?
Yes, sir.
All right.
Just somebody very quick, can I introduce my daughter to the court?
Sure.
This is Angel. She is my daughter. She wanted to come and see me argue today.
Okay.
Dragons is the highest math grade in the school. She wants to be in the school.
Okay.
Great.
Good for her. All right.
You let me know when to begin, or should I? Well, I am Shane Perry for the plaintiff appellant, Ms. Walker. And Your Honor, I've got about 5 minutes that I want to get on record, but if the court has questions, would you like to start with the questions? And I'd be happy to start there as well.
You can make your presentation however you choose.
Thank you, Your
We'll
Honor.
ask a question if we have one.
Yes, Judge Niemeyer, I'm sure you will. May it please the court, there are three basic parts to this appeal. First was the issue of bifurcation. I would like to point out that there was no ruling at the October 23rd hearing, the 12B6 hearing. The court never discussed bifurcation. And in fact, it's not in the order. It was basically the result of the order for the 12B6.
Well, I might suggest that this is not bifurcation. This is really a limited order for discovery. And of course, that's done oftentimes, for instance, in connection with motions for a personal jurisdiction, a court will issue, say, discovery continue on personal jurisdiction, we'll decide jurisdiction first. And in this case, as I understand it, the court thought that the dispositive question was duress and decided that let's limit discovery to that and see what happens since that's dispositive. And that seems to be a fairly discretionary decision for the judge, isn't it?
Exactly. It is a discretionary decision, and to have discretion, the court would need to have an analysis. The companion propane court points out that they were discussing bifurcation, but they were saying that it's determined on facts and circumstances. And the court never brought up the idea that this case would be, and I'll use the term bifurcated because that's the effect of it.
It's not bifurcation. Bifurcation is when you separate a trial, elements of a trial. You separate liability from damages or something else. This was discovery.
Okay. Yes, Your Honor.
It's a matter that's rather much in the hands of the trial judge to make a determination on how to conduct discovery. And we don't tend to wade into that too much. You may have a point in terms of how you think it should be handled, and there are different ways in which it is, but it's pretty much in the trial judge's determination.
It is. And if we had had an opportunity to argue that with the court, that it should not have been split the way it was, limited initially the way it was, the court should take, as the companion propane said, all of the facts and circumstances into it in any discretionary decision.
But do you agree with the court that if the main issue seems to be the undue influence, and until that's decided, if you win on that, then the other issues would be discoverable, I guess. But if you lose, then, I mean, that kind of ends the case, right?
Yes, Judge Benjamin. One of the problems was that the court, of course, took that decision away from the jury. And the court, if you look at the language that the court used during the hearings, was that he was making the decision that there was no undue influence, considering facts. And I can read that from the trial transcript, the hearing transcript, if you like. But he made decisions on facts. He first found that there were no facts, and then talked about the facts that he used to make his decision. I think that the judge took this clearly out of the hands of the jury.
That's the crux of the case. This is a summary judgment. The evidence is viewed in a light most favorable to you on it, and the issue before us is there an issue for the jury to determine? I think one of the significant things is this is controlled by North Carolina law.
Yes, Your Honor.
And the question then is the issue of undue influence a question of fact, or is it a question of law?
Quite clearly, it's a question of fact. The court's discussed that. North Carolina Supreme Court several times has discussed that it is a jury decision. And the Fourth Circuit has also decided that in the McMurray case. But Barbie, 190 NCAP 319 at 358, said it's a jury decision. The Link
Well, I
case-
would think there's no question that it would be, just as negligence is, but the question is whether you advance enough facts to raise a dispute on that. And in this case, as I understand it, the city simply held fast to its $45,000 offer and decided it didn't want to offer any more. And that's all they did. And it's hard to conclude that that was undue influence. Now, she had personal circumstances that were difficult and obviously sad, but she did receive a settlement which was above the estimate to fix the condition, and she chose to take that.
Well, a couple
And
of...
she said she chose to take that, and she had a lawyer, and she chose to take it because she couldn't delay. She needed to have her house back, and that's all very understandable. But the question then is, while it's a question of fact, you still have to present enough facts to show there's a triable issue on that issue.
Yes, Your Honor, that is exactly right. And so we did produce facts. Now, if you look at the Curl case, it discusses the facts for the jury to consider, not the judge. First was her economic condition. She is in formal pauperis before this court, and in her affidavit, by the way, the first RAC, that was a signed affidavit where she wrote on it, says, "I'm homeless." That was notarized. That's a signed affidavit. But then later, when she produced her affidavit, she discussed very clearly her homeless condition and her impoverished condition. The Curl case, the Curl court said her age. The court can take notice that she's 78 years old. Her lack of bargaining power. Many cases talk about the government has superior bargaining power. He's talking about Lockheed Martin. You know, the government has superior bargaining power of her. These are all factors that the jury must consider. Her physical
The city
mental
didn't
condition.
have to offer anything, did it? It could have said, we don't think we have liability and we're going to go to trial. Would that have been undue influence? I mean, that would have, the city chose to make an offer, but they didn't have to choose to do that.
Well, Judge Niemeyer, they had a program, is what it was. It was a $15,000 program.
Well, I understand that, but then she retained an attorney and the city, the attorney negotiated a $45,000 offer.
That's not completely the case, Your Honor. What happened was, she didn't hire me, I was pro bono, and I argued with them, and they kept saying no, 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 and we got on the news twice, and they got embarrassed, and then they suddenly changed the offer. And by the way, the new RAC that they put out said she couldn't, see, the initial RAC said that she could sue for certain things. The new one, no suit of any kind. She couldn't bring in certain evidence. It struck certain evidence from any kind of a case. It was a terrible contract. And again, these are factors that North Carolina said the jury is to consider, and we have evidence for every one of these factors.
That's the key of your case, is the determination of all these factors to be considered in determining the fact of whether there was undue influence. That is more appropriately determined by a jury. The judge said essentially what Judge Niemeyer has parroted here, that is, it was a difficult decision, but it was voluntary. The question is that a question for the judge, or is it a question for the jury?
Absolutely.
And if it's for the judge, then it must be that viewing this evidence in a light most favorable to your client as a matter of law, it is against it in order for us to uphold this on summary judgment. It's only a question, does it go to trial? It doesn't mean you would win at trial. It simply means that it is a matter that ultimately could go before a jury. But I will turn to a question, and that is, I think the factors here are strongly in favor of some indication of undue influence. But there is this element, this factor here that you, the lawyer, represented her. And the cases, there are cases in which, there have been cases which lawyers have represented, but the question is, did it go beyond a factor to being a decider for how a summary judgment should be determined? The fact that she had the advice of counsel in this process. Admittedly, that advice you gave was rather interesting because it just said the whole time this is undue influence. She has no choice in it. And I think that's the troubling part about this case is if this woman had money, she wouldn't have had to do this. But she's living in a house and she's homeless. And the city of Charlotte floods her house full of sewer from an outside source. I guess it's determined if it comes from there. I don't know if they admitted liability or not. But the house is flooded with sewer. She cannot live in it. And I'm not sure as to whether the $45,000 was that above what it would take to repair it? Because I understood for the record it was nowhere near it. Oh, is that true?
Well, Your Honor, their preferred vendor said that it would be $38,000 to get her in the house. Now, understand that she and her husband spec built this house in the 80s, and she paid for this house. And I was trying to work with Cardinal, trying to say, just get her in so she can at least sleep on the floor, because she told me I'm going to be sleeping in my car with my dog. She called me up and said, I don't know what to do. And so I said, I'll do what I can. And he said, I can get her in.
What does it mean, $38,000 to get her into the house?
That means she doesn't get furniture, she doesn't get clothing, she doesn't get her time being away. She worked 2 days a week at a church. That was her job.
But did it include all of the, I mean, there's bacteria, there's all kinds of things that get into the house.
Right.
When sewer gets into it.
That's right.
You just can't move into a house. I kind of know that. But so I'm trying to understand, what did the $38,000 include?
There was abatement included, but I'll tell you, they didn't take hired, and they said, no, we're not giving you that, you get nothing. That's a factor, by the way,
So $20,000 is what you're talking about.
not $20,000, because that was she was going to settle for. We all know
45
that-
plus 20 is 65.
Yes,
You
Your
offered
Honor.
65, you would have been
Because-
happy with that. That's $20,000.
No, sir, Your Honor, we would not have been happy with that, but it would have given her a chance to buy some furniture and clothing.
You just avoided my question in terms of, if you offer someone, that's a stronger case than even where we are now. You offer to settle, you do it, then there's a strong belief, there's no undue influence on that if you offer it. That's $20,000. So we are arguing, this case is about $20,000 based upon your statement there.
No, sir, Your Honor. We were just trying to keep her from sleeping in her car. And I said, well, if I offer him $65,000.
I didn't ask for your
maybe we'll
motives.
move up.
I'm saying you offered it. That's all I need to know. You offered 65. It puts in my head, at least in terms of what we're talking about here, that could have settled the case, is $20,000. Had they accepted your 65, you wouldn't be here today. Is that correct?
Well, if they had signed it, we probably would have signed a contract on that, but that's if. I don't know. I mean, I offer.
If you offer 65, they accept, you're not here today. Correct?
Well, Your Honor, I would say probably not, but we weren't there.
How
She
you gonna be
didn't
here?
have- Well,
I
I'm
just told
saying,
you, if you think you've got, if undue influence is hard, how are you gonna get it when you offered it?
I don't know for sure that she would have signed it. Understand, I'm trying to negotiate with the city to get her back in her house.
You offered it, she didn't offer it.
I spoke for her, Your Honor, and
But you hadn't consulted with her before you offered
She hadn't
65.
she hadn't had a chance to make a final decision on it. I did offer, and they did not respond to that. They said no. But I was trying to save this woman's life. She can't, at 77 years old at that time, sleep in her car in the winter.
Your efforts in what you're trying to do, I mean, it's admirable what you're ultimately trying to do. I'm just talking about the law on it, and I'm just wondering if it is a $20,000 case, it may well be something that can be handled without us having to issue an opinion on this case if it comes out. But that's something you guys can discuss when you go out of the courtroom on
Yes,
this.
sir.
But I'm just amazed. I was thinking maybe the figure was gonna be that you had offered was something different, but an offer is, but that's your offer, you say, okay, all right.
And that is a factor, Your Honor, to consider by the jury. And all of these factors, and by the way, it's about me being an attorney on her case. The Curl case, when it was listing the factors for the jury to consider, attorney was third on the list. Age and mental and physical condition was first and second. They didn't even list it as the most important factor or first factor. It's just a factor for the jury to consider. The judge does not get to say, you had an attorney, so the jury doesn't get to consider the other factors. It's one factor.
So, just a thought. If we rule in your favor, aren't you gonna be a witness in that case?
I don't think I should be, but if
The
that's the
question is
way.
whether you should be. You're the one that have a lot of direct evidence on this, and I'm just wondering.
Well-
But it's something, I just throw it out for some thought for you in terms of if it did go that way. Question is, should you be the lawyer handling this case?
I think an attorney should never have to violate attorney-client privilege, ever for any reason. And I'll go to jail on that. But I think in this case, the judge might order, and I might do it. I might have to. I don't know how hard I would fight in this case, because there really wasn't a lot to talk with her about. But I think that that is a sacred oath that I take with my client, that's sacred duty. So if I'm called to do it, in this case, I think I might, because it just wasn't a lot.
Well, there's a lot of situations where lawyers end up having to testify because of the advice that they give to the clients. So that's not anything unusual. But don't you, in considering the independent, the factors that we're to look at, one of those is, did this victim have independent advice? And she did.
She did.
And so in looking at this, it seems as if the district court judge is saying that there's no genuine issue of fact for the jury to decide because of these factors of having counsel and counsel advising and the amount of money going from $15,000 to $45,000. So what's the genuine issue? I mean, what's your best case for the genuine issue of fact on summary judgment before the district court judge?
The jury gets to decide if having an attorney meant there was no undue influence. The jury gets to decide that. It is a fact, and it is a factor, one of about 7 that the Curl Court listed, that the jury gets to determine. We have facts before the court on every single one of these. And the court said the jury doesn't get to hear those. I think this is the most important. I think it's overwhelming, and the jury doesn't get. But it's not. It's one factor. Yeah, she had an attorney. That's one factor that the jury gets to hear and decide on.
Okay, I see we're beyond our time. You have some rebuttal. And,
Thank you, sir.
We'll hear from Mr. Bader.
Good morning, and may it please the court. Stephen Bader here on behalf of the appellee of the city of Charlotte. This court should affirm summary judgment for Charlotte because Ms. Walker's evidence does not forecast a triable claim for undue influence. In North Carolina, undue influence happens when a defendant asserts such control over a plaintiff that the plaintiff's decision is effectively the defendant's. And what the evidence in this case shows is that this was a very difficult decision for Ms. Walker because of her personal circumstances. But it was her decision. And on those undisputed facts, there is no question for the jury. The court really can start with the narrative affidavit that Ms. Walker submitted after the hearing on summary judgment. That's at pages 216 and 217 of the joint appendix. And what she writes in that narrative is she's putting this together. These are her words. Her lawyer has helped her. That she was concerned about the uncertainty of litigation, the time, the expense, and the outcome. She needed the money, and she understood that what the city of Charlotte was asking her to do was release her claims. It was a tough choice, but she decided to do that. In addition,
Well, you know, undue influence in North Carolina is a jury question. We are viewing this in a light most favorable to her. There may be things against her, but it's the light most favorable. and North Carolina presents in the jury question, they've actually been pretty lenient in terms of getting this issue of North Carolina. A number of Court of Appeals cases and your Supreme Court cases deals with that. And the issues here that come up, what are those factors? I mean, she's an elderly lady, if you consider late 70s elderly. She's had some physical and mental conditions to deal with. She's in a situation of distress because she's, I guess, living in a car, or since she's going to be homeless under this. She's not in a position to exact anything against the city on it. The city has, and you think about what actually happened, she's in a home, she hasn't done anything, and it becomes flooded with raw sewage. And that alone, I don't know what the prices are in Charlotte, but I don't know anyone that would fix that for $38,000. I mean, but I don't know. It may well be, because we're allowing the evidence here. But when you come down to it, the factor here that's the strongest here is she's represented by a lawyer. But the question is, I don't think that's dispositive. That's something a jury would have to determine was, does the presence of a lawyer under North Carolina law, because undue influence is a question of fact. So the only question here is, does a jury get to decide this case? And, that's the posture. We could talk about all the things against her, but it's the things that's for her that really form the basis for whether summary judgment and whether there's an issue of fact that it exists here. And all of these factors are there supporting the undue influence call. But it's, admittedly, the facts are difficult here because she did sign this. Albeit she wanted to add that language in there that I'm doing this under undue influence. It's a strange case, I would say. I don't think I've seen one like it.
Well, let me try to address
Let me add this.
Yeah.
Only reason we're here is because this woman is poor. If she wasn't a poor woman, she wouldn't have had to put up with this. And poor people whose houses are flooded under these circumstances, the city of Charlotte puts a $15,000 cap on what we're gonna pay you if we flood your house through our negligence or whatever, I don't know, with sewers. I mean, I'm thinking the initial one's 15, then it goes up after the newspaper to 45,000. And it's something to consider that if this woman was not poor, this would never have been here, and she would have had some options to deal with. But when poor people, if you can't fix it yourself, you can't do it, you either live in a house with sewer, or you take the whatever the amount, and try to do the best you can with it. And all the other things in there, your furnishings and all your clothes or whatever is dealt with, you just got to live with that. And there's something there as to whether that goes to undue influence is another question. But it is a factor in this case for that. Any jury that get that case, that's the problem. It's not that the jury can't decide the case, but that's a fact the jury is going to pick up on in any case like this if it does survive summary judgment.
Let me try to address those various concerns, Judge Nguyen. So first of all, the program that you're referencing is not a cap on what somebody could get against Charlotte. It is a program that Charlotte has in place that says if you have flooding through our sewer mains, you are entitled to repair costs and restoration up to $15,000 without having to show fault or otherwise. If it happens,
Did you have to sign a release to get that of any type?
The release that you would sign would just reflect that you were paid under the program, but not that you would otherwise be releasing claims.
So you could take the 15 and still sue?
I don't want to misspeak, and I'm not. I don't want to.
Because otherwise, it's a cap.
Well, the cap doesn't apply if a negligence claim is brought. So if somebody were to bring an action against the city of Charlotte and say, your negligence led to this damage to my home.
Well, I'm trying to understand what you're just saying. You're saying that when the 15 was offered, you take the 15, you still can sue. So she should have just taken the 15 and then brought this action.
No, I don't.
Was,
I
I
ju-
think, just to lend a little additional light, my understanding was the 15 was a no-fault.
Right.
A no-fault
Right.
program, and if fault is alleged, then the normal, traditional tort case could go ahead and
That's right.
negotiations. Is that
That's right.
the
That's
correct
right.
understanding of the law there?
That's right, and I believe the
But let me make sure I understand what you just said there, because I just asked you, if she takes the 15, can you sue?
I
If you
don't-
take Judge Niemeyer's version, yes, you can because it's no fault. And if you have fault, you can pursue that. This is just something to help you out administratively. So my question is, if she had taken the 15, could she have brought this action without being anything impeded?
I don't believe that she could,
Well, how is it no fault?
because she doesn't have to prove a case.
I got that for the 15.
Right.
But it doesn't, the question of this case has to do with the release, not the question of whether or not it's no fault. We know it's no fault. They gave her $15,000. But the question is, when you give her the $15,000, do you put conditions on it so that she cannot sue if she has damages of $115,000?
Well, I believe that she would, but that would not be unlike any plaintiff who says, you engage in tortious conduct, you are liable to me for a certain amount, I'm not going to turn to your program, which could allow me to recover a lesser amount irrespective of fault. I'm going to pursue a lawsuit in the tort system, prove up my claim, and prove up my damages.
So she wouldn't be allowed to take the $15,000.
Yeah, that's correct.
That's the problem.
Well,
Because the $15,000 doesn't fix her house at all.
Well, then her-
She's poor. She cannot get in a home. She has no money. She's old. She's living by herself. She is in a very vulnerable situation. Had it been a different situation in which she had money or she had family or some others to help her, it's a different situation. It is preying on the poor.
Well-
It is no more than that, and it is a program. Maybe if you do have $15,000, you can do it. Who would take it? The only time you take it is when your damages were $15,000 or less. But this program doesn't matter. I mean, where does $15,000 even reasonably cover a house flooded with raw sewage? I mean, why would you even offer that? It just almost makes no sense when you think about it. It's like, I'll give you $15 if you'll just take that and be done with it. Doesn't matter if it's 15 or 50. There's no connection between 15 and that amount of money. Her damages are just on its face way more than that. You don't need a contractor to come in and tell you that anybody who has a house flooded with sewer, that damage is going to be a lot more than $15,000.
Let me try to address a lot of this. Number one, the city of Charlotte is under no obligation under North Carolina law to have any program at all.
Probably shouldn't if you're going to treat people like this.
You
should just allow them to just sue. Why even dangle this out in front of them?
Well, I don't-
And then take the damages for doing nothing at all, for not settling and whatever may go with it. I mean, but again, I'm not faulting the city of Charlotte. The city of Charlotte has $15,000. It works for those who have damages, maybe 5 or 10 or 15 or something like that. But someone who has this kind of damages, it clearly cannot work. And to even put them in a position where they can't sue to get it.
Well, they can sue to get it. There's no reason she can't sue to get it. She can take the position that what's available under this program is insufficient for her damages and she wants to bring a lawsuit. There's nothing that would preclude her from doing that.
And you would not come into court and say that she's taken 15 and the matter's been settled.
Well, she wouldn't take, at that point, she wouldn't take the 15.
Doesn't
We're
your,
being circular. I'll leave.
doesn't your, the contractor that, with the estimate of the 35,000, I think is what she ended up.
38.2.
38.2, that was the city's contractor, right?
That was.
That wasn't an independent contractor.
The city had a list of preferred contractors, and that was the first one on the list, and so Ms. Walker contacted that contractor and asked them to put together the estimate, and that's what they put together.
All right, and then you offered the 15,000, you offered that offer was made before the contractor came in?
I think that's correct, yes.
Okay.
Yeah.
I mean, I guess the difference is, really, if you look at this, if I understand it correctly, the 15,000, if somebody's damaged and assumes that there's not too much damage, that 15,000 is no fault, nothing has to be shown, you get 15,000. If you have bigger damages and you believe the city is liable, now in this case, I'm not sure the city was negligent. I mean, in this case, somebody put something in the sewer line unbeknownst to the city, and it blocked it up. So it might have been a very tough case to get to proceed in the litigation. And I'm sure the attorney advised her of that problem too. I mean, we don't know who clogged up the sewer, but it wasn't the city, according to the facts alleged in this record. And so she now is facing $38,000 in damage, and she can't take the 15, and she decides she's going to go the route of suit, and the city negotiates and gives her 45, and
Right.
she feels necessary to take it, but
Well, that's right,
but
and
that's, the question is, undue influence under North Carolina law uses the word overborne, and the person undue influencing her has to overbear her such that that person's decision is her decision.
that's exactly right.
And that, there's no evidence that somebody else made that her decision. She had a difficult situation, there's no question. But overbearing somebody has to be some other person, either the opposing party, or maybe her attorney had to overbear her such, but I'm not sure that's so, because the attorney has his own ethical obligations.
Certainly, and I don't think anybody's suggesting that, but yes, I mean, that is what she needs to show under North Carolina law. It's not her decision, it's effectively somebody else's decision, and
That's what they use in the case after case. It has to be tantamount to somebody else's decision.
right, and that's I mean, I think everybody is sympathetic to Ms. Walker's situation. It's very unfortunate, but, you know, the civil justice system depends on finality and certainty, and so parties to a dispute will say, here are the terms that we're offering, here are the terms we're countering with. Ultimately, you know, if parties come to an agreement and that's memorialized in writing, they need to be able to depend and rely upon that. I mean, that system doesn't work if somebody can say, yes, I did ultimately accept what you offered, but my personal circumstances were such that I didn't think I was best served by pursuing further litigation.
Is this a damages case, or is it a question of liability in question? Is liability in question here? Because this, as I understand, this occurred outside the house in the lines there. I'm pretty certain that when things happen in those lines outside, that's kind of outside of the household for time. But depends on where it happens or how it happens, but there are a lot of factors involved. But that's not an issue for us. The issue here has to do with, in terms of this release, and whether or not there's undue influences. Not a question of who's liable for it. It may well be, but I don't think I've heard anybody get up and say the city is not liable, or it is conclusively at that point. We maybe not reached that. I'm not saying it's been decided. But in terms of what's going on here, the question again goes back to, and you said she didn't have to take the 15, she didn't have to take the 45 if she wasn't poor. That's the point I'm making, is that you have a factor in here that you are dealing with citizens who, those who are poor, cannot afford, may be homeless because of some act they allege, and a light most favorable to them, you have to accept, is caused by the city. And in response, the city then puts them in a position where you either sleep out in this car, it's fall in Charlotte, it's going to be cold, or you're going to be homeless, or you take this and you can minimally get back in your home, but you will not be compensated for the damage or for what you suffered here within your home.
But
Because you are poor.
the difficulty with that, Judge Wynn, and I understand your sort of policy level concern, but the law says that then by signing the release, that's not your decision. And the record here shows.
No, there have been cases in which undue influence have been upheld, where there have been releases signed. A number of cases on that. The signing of the release itself is a factor. A jury gets to decide. A jury could agree with you totally. Sign the release, you had a lawyer, so you don't win. Or it could say, She's an old woman. The city should have done this under this circumstance. The city pressured her. They knew she didn't want to do it, and they knew her circumstances. And I mean, you shake your head on it. I'm gonna say these are factors. I'm not saying they weigh against you. I'm not saying they weigh for you. I'm saying factors that the jury can decide.
If I could just address that, though, we're talking about evidence in the record. There's no evidence in the record that Charlotte twisted her arm or presented an ultimatum or did anything. They said, look, you're asking us to just pay you without any consideration of fault or negligence. You are making a demand. We are going to pay you this amount of money. You don't have to take it. In fact, she did initially, sign, I don't have a choice, I'm homeless, when she first signed the release, and the city of Charlotte said, we're not going to accept that. So if she wants to sign the release, she can, but she doesn't have to. And at that point, she signed it unaltered. So I think, anecdotally, there could be sort of some argument or a suggestion that she was strong-armed by the number, but as a factual matter, there's no evidence to that effect. And that is the difficulty when you look at the case law, because typically this comes up in, estate disputes and things of that nature, where you've got somebody who may be infirm and is having one-on-one private conversations with another person, and after those conversations occur, they make a change to their estate plan to that person's benefit. And in those kind of circumstances, our North Carolina courts have been willing to say, the jury can hear that evidence and decide, given the individual's potential competency limitations.
So when a lawyer communicates, I'm thinking in communications that she's losing her housing, sleeping in a car, will be sleeping in a car. She has no other options. She has no choice but to sign this out of desperation. She's in her late 70s. She won't last long living in a car. I mean, that's not
the difficulty, Your Honor, is that Charlotte could just say it's a $15,000 cap or sue us. And that wouldn't give her a claim for undue influence. She wouldn't say, I have recourse against you for undue influence because by not offering me what I wanted, you have forced me to bring a lawsuit. That doesn't make any sense.
Well, this seems something that you got someone in a desperate situation, if they say they have no choice, and you offer them some money. It's like if you're drowning and you have to you throw a paddle, so you can take this paddle if you want or not. If you didn't take it, you're gonna drown. You take the paddle, and he says, well, now that you took the paddle, you can't, there's nothing else you can claim I did that's wrong on it because I gave you a paddle, even though I'm the one that put you in.
Well, I think the problem with your analogy, as I understand it, is that Charlotte didn't put her in the water or in the drowning.
Most favorable under summary judgment, they did.
Well, no, because this is not a situation. That analogy may work if Charlotte said, we're at fault. We are at fault for the sewer loss. We agree we're at fault for the sewer loss.
What if she alleges Charlotte is at fault?
She didn't. She
allege that Charlotte. She didn't say that Charlotte was at fault.
She never put forth any evidence to say that Charlotte's negligence caused this. And my concluding report, I just want to say this. I mean, this really is a question of, does the civil justice system going to let parties settle cases or not? Because if they're both represented, and one side says, these are our terms, the other side says, I don't really like them, but I'm going to take them because that's what I need to do, the system breaks down if that just turns into a lawsuit for undue influence after the fact. And so for those reasons and other reasons briefed, and the court should affirm summary judgment. Thank you very much, Your Honor.
Thank you. All right, Mr. Perry, you have some rebuttal.
A couple of things I want to, excuse me, may it please the court, I want to correct a few issues. Every single case that has to do with undue influence comes from a contract that was signed. Every case.
The problem, there's a fundamental underpinning here is this is a lawsuit where you're asserting that the city did something wrong, and the city should therefore answer for damages. The city takes a position, at least on this record, that you have to prove it's wrong because it's not going to confess that it stopped up that drain. There was some contractor's material in there, put in there that stopped up the drain. So the city could say, we're not at fault, sue us. In that circumstance, you would have no basis to be here And what the city says, we have a program that with no fault, you can take 15. She wanted that first, but then she got the estimate and hired you, I guess, and negotiated the case. But the negotiation of every case balances liability and damages and the decisions. And it seems to me she didn't have to sign it. She could have litigated it if she thought she was right. But the city didn't confess negligence, and the city has no, that I know of in this record, has no absolute liability. You would still have to demonstrate fault on behalf of the city with respect to who clogged up that line. And I think that might have been a tough situation. You might have ended up with nothing.
Not at all.
And so the question is, when you demand 65 and they say 45 is our max, and we're going to hold fast to that, that's just typical tort litigation settlement. And the woman was in dire straits, and she said, I'll take the 45. That's the best I'm going to get in this. And I may not get any. I'm sure you advised her that in litigation you may not get any. I'm sure you would have to.
Your Honor, the factors about how this got clogged up, it was way down the street, and well, not way down the street, but way out of her yard. It wasn't in her house.
That
It was
doesn't
on
have a
their
thing to
side.
do with it. The
Well,
thing is, what caused the backup? And the city didn't cause the backup.
The city did cause the backup.
Somebody clogged it up.
We have an expert witness who's going to testify about that, and we did not.
It's not in the record.
It's not, because we asked to have discovery on that, and the judge would not let us have discovery on
I
that very issue.
understand, but we're here in a situation where we're negotiating a settlement, and we're not trying the negligence case. You have to prove negligence on the part of the city. And the only evidence is that the line was clogged by, and there's a description in the record what it was. It was what is contract?
Sheetrock tape.
Sheetrock, okay. And that clogged up the sewer. There's no allegation that the city put the sheetrock there. Somebody else did.
The
So it doesn't matter whether it's in the house, outside the house, it's down 3 blocks. It caused her, that sheetrock caused her damage. And so now she's asserting that the city's liable. Well, she might be able to get a claim, she might not. But that's what litigation's about in the tort system. And so there was a negotiation. You were able to get the city to go up to $45,000. She had a $38,000 estimate from a contractor. You gave her they offered $45,000. You demanded $65,000. They wouldn't budge. And so now you could decide, we'll go to trial, or we'll accept. Now, her circumstances, she made the decision, and it was, as a matter of fact, it clearly was her decision, because she wrote on there, I'm protesting because I'm poor, and that evidences that's her decision. And then the city said, well, we can't accept that, and so she did make the decision to sign a clean settlement. So isn't there a problem here? I mean, the city didn't do anything to overbear her.
Well, there's a couple problems with this analysis. First, the city did not try to bring in any other defendant to counterclaim against someone
They
else.
didn't threaten her, they didn't say this or that, they just held fast to a position of their assessment. And I don't understand what's wrong with the city assessing its liability and saying, we think the most that we should pay on this case is $45,000.
Your Honor, the idea of having an attorney is one single factor.
Well, let me ask you this, because I think Judge Niemeyer brings up a good point. One of the things that you have to show is this overbearance by the city, and I'm not sure if there's anything in the record. Can you point me to something in the record that shows the overbearance? It says it has to be more than just mere pressure, and I'm trying to find something where it says that it was more than just mere pressure.
The facts and circumstances are what bring pressure to the person who
No,
is in
by
a
the city, because you got to be able to show that there's this overbearance
Right.
for this undue influence.
The cases are very clear. The government always has a superior bargaining position in every situation with every person they bargain with.
But that is in every single case. There is
Right.
usually a differential in bargaining position. And the question is, difference in bargaining position doesn't mean overbearance. It just means you can negotiate or you can hold fast to a position. But that's why we have courts. The tort system allows you to go to court to prove your claim, and get the full damages you want. Maybe you could get more than 65 if you proved it, but maybe you could get nothing too. So that's the assessment that you as a lawyer had to make and advise her. And I assume that that was done because you're the one that communicated with the city. I think it was you, wasn't it you?
It was me,
Yeah,
yes, Your
yeah,
Honor.
yeah.
And that,
Anyway,
if you remember, they tried to take me out of the position by threatening my law license. And so as far as me being an attorney, that's a factor for the jury to consider as well. I wanted to fix some things that were stated
Well-
earlier. I did not help her write that. She wrote if you look at it, it's not the words of a lawyer. I told her, I'm not telling you a single word to say. You tell the court what's on your heart and what happened to you. I did not
That's fair
write
enough,
that
that's
for
fair
her.
enough. No, and everything she says there is probably true.
It is.
But the question is, as a matter of law, when you're settling a tort case, does that make a difference? And the question is, she has to make a very difficult decision, and she expressed the difficulty in making the decision. But the question is, was she overborne by threats of the city, or did the city say, we'll condemn your house and all this stuff? There's none of that in the record. And so, well, your time is up, unless, I'll give you 30 seconds to respond to my...
That question about overborne, but being overborne, that is answered by the jury looking at the Curl factors. That is, and there is nothing in any law anywhere that says her having an attorney is the most important factor. It's not listed first.
Let me just ask one question that's on my mind, and it has to do with this business of once the city does have some indication that she thinks it's undue influence, she puts them on notice. They won't let her put that up there. It would seem, did the city then put any language on this release to say that you are now signing this voluntarily, knowingly, without any notion of undue influence? Is that on the release?
No, I don't remember, but I will tell you what happened. And by the way, it is called a release of all claims, and that's what they put in her hand at 6:30 in the morning while she's standing in her yard in her bathrobe. That's what they had her sign, and a release of all claims. And so, no, she didn't have a chance to sue, but I will tell you what happened. They came back with that same release, and she wrote the language, and she said, I'm homeless and I don't have any other choice. And what did they do after that? They said, Shane, you get her that language out of there, she gets nothing.
They turned
And
it down.
came back-
Basically, they did not accept it.
They came back with a 3-page, it was one short page, and now it's 3 pages of things she's got to weigh.
The problem with they didn't accept it didn't change how she viewed it. In other words, if she was homeless and she said she had no choice, they said, you got to take that off. It didn't change that she was homeless and had no choice.
It did
It
not.
simply said, we won't let you sign it without putting it up there. That's a difference.
Okay, well, we've gone several minutes over, and we'll come down and greet counsel and proceed on to the next case. We'll hear from you whenever you're ready.
Thank you, Your Honor, and may it please the court. Mark Reverace here on behalf of petitioner Extra Energy Incorporated. Mr. Culbertson has 5 years of underground coal mine employment. He also has a number of years of surface coal mine employment, some with Summit Services and some with Extra Energy. The question that this brings up is whether Mr. Culbertson has enough coal mine employment in this federal black lung claim to invoke the 15-year presumption. Specifically, does he have at least 10 years of his above-ground employment that is considered, quote, substantially similar to the conditions in an underground mine within the meaning of 30 United States Code, Section 921, subsection C4. The Benefits Review Board found that Mr. Culbertson did. This finding of substantial similarity is wrong as a matter of law. It relies on invalid deference to a regulation promulgated by the Department of Labor.
Well, how do we handle the regulation? The regulation says regularly exposed.
The-
That substantially similar means regularly exposed to coal dust.
Yes, that's a very good question, Your Honor. So the problem with the regulation,
Well, I know what the problem with the regulation. The regulation appears to be broader than the statute, but you didn't say anything to the ALJ, nor did you say anything to the board.
a very good question. I'll address that, and then I'll come back to the problem with the regulation. This argument as to the definition of substantial similarity and the deference to the regulation wasn't a reasonable, viable argument until the U.S. Supreme Court decided Loper-Bright Enterprises v. Raimondo. That was June 28th, 2024. All the litigation in this claim took place before that. This court had, in 2015, had upheld a portion of that regulation, but only as it related to applying rebuttal limitations to employers. So the argument, had I made the argument, Your Honor, to the ALJ and to the
It could have
benefits.
been made, and we've indicated it could have been made. We get this type of situation all the time. If you think the regulation is too broad, you can challenge the regulation, and you can, but we also have additional conclusions. In this case, we have factual conclusions of extensive coal dust around this worker while he is working above ground, and both in this job and in his prior job at Summit.
But the argument, because this court in West Virginia, CWP Fund v. Bender, had upheld this regulation on a separate point. However, at that point, it wouldn't have been meritorious or viable or reasonable to argue that the ALJ and the Benefits Review Board should not defer to the regulation, because the entire issue of deference has been set aside, the entire issue of Chevron has been set aside. That's what made this argument viable. And regardless, it had
Chevron lets you challenge regulations. It didn't avoid it. It just required deference in certain types of circumstances. And but ultimately, people challenged the regulations under Chevron. But you still could, if you were upset about the way they presented evidence and it didn't fit substantially, as you're pointing here, substantially similar, which is the statutory language, you didn't make that argument below. There's not even a hint of it.
Again, I'll reiterate, it wasn't viable, it wasn't reasonable. There are exceptions to whether this court might consider there to be a waiver or a forfeiture. One of those is whether it was reasonable at the time to make the argument. I think the argument as to deferring to the regulation, I think the argument as to whether to follow that regulation was foreclosed and was not reasonable based on this court's decision in Bender. It was in June 2024, when the U.S. Supreme Court directed that this court and all courts conduct an independent analysis and determination of the statute without deference to the regulation, that this became an issue. So,
Well, I guess the other problem you have is the question of waiver, because you don't discuss the forfeiture obligation in your brief. You just kind of go straight into Loper-Bright, and there's some discussion, but there's no discussion, this discussion that we're having now as to whether or not there's an exception or if the issue was forfeited.
the issue of forfeiture is briefed in the reply brief, Your Honor, and there's a three-piece framework under Ed Potter, and that's fully addressed. But the question is, as to forfeiture, ultimately, was it unreasonable to have not raised this issue before? And my position is, until the U.S. Supreme Court invalidated Chevron and directed this court to make an independent assessment of substantial similarity.
Is it correct that they invalidated Chevron totally? I mean, the court, if you look at Loper Bright, and the language is that the court must exercise this independent judgment. Then there's an exception to it. That is when a particular statute delegates authority to the agency. This statute delegates authority, does it not? Doesn't it delegate authority directly to the Secretary of Labor to set certain standards? So even if you, under your contention, Loper Bright has this effect, it didn't completely wipe out what an agency, that an agency is just there in some perfunctory capacity. When the Congress specifically gives this delegation of authority, is that not an exception?
That is a factor to consider, and
No, it's right there in the court. It says, but there's an exception when a particular statute delegates authority to an agent consistent with the constitutional limits.
that's the question, consistent with the constitutional limits. And the Skidmore deference, or not, it's not deference, the agency can have a power to persuade, but it's only to the
What
extent.
limits the Congress from giving the Secretary of Labor delegating authority to set up standards for an act that it creates?
Here, the statute.
When you think about it, there is still a place for an agency in this country. Loper Bright didn't come and say, well, anything the agency says, your courts can just ignore it and do whatever they want to do. I mean, you think about agencies like the Nuclear Regulatory Commission. We have independent authority. I mean, don't you think there is something in there that says, you know, if that agency determines it, we ought to have some deference to what they're doing?
Not,
Specific type things like that is one thing to do factual, but something that requires some type of expertise. In this instance, the Secretary of Labor is given this explicit delegation to set standards.
I disagree with the explicit delegation of authority as to substantial similarity. The statute here, subsection C4, 921, subsection C4, the regulation has to mirror this language, because the language is specific, and it says, quote, "The conditions of a miner's employment in a coal mine other than an underground mine were substantially similar to conditions in an underground mine." The finding that should be made below and what the regulation should direct is the language of this statute. Congress said the conditions need to be substantially similar. The regulation goes beyond that and says, well, we're just going to throw out substantially similar. We're not going to consider other factors. We're going to ask one question.
Congress, I mean, when you look at the statute, it does say expressly delegates to the Department of Labor the authority to give meaning to what constitutes disabled and due to black lung disease.
Right.
And when you approach it from that perspective, you want every time a case come up here that we as judges are going to be doing this? You think that Congress or that even the Supreme Court ever intended that we judges would be in a position to become experts to the level that the Department of Labor and those who do this on a daily basis?
Your Honor, I want this court and all other courts to be experts in statutory interpretation. That is what Loper Bright instructed. Loper Bright says that this court must independently interpret 30 United States Code, Section 921C4, not to delve into the details of what, pulmonary function testing, those standards. That might be appropriate to look to the director to determine, well, what does the director say? And
Even if Congress says, regarding to that statute, that in a particular statute that delegates the authority itself explicitly, we still have to do what you say.
It's not what I say, Your Honor, it's what Loper Bright Enterprises requires. And this statute.
I just read the language from, that language that I read came straight from Loper Bright. That's not something I made up.
So does the language that this court must determine what is the best interpretation of that statute.
Agreed.
If
If it does not involve a particular delegation by Congress to the agency. Agreed.
I would not agree to that other part. It's this court fundamentally.
You're not agreeing to Loper Bright. I'm just saying, I'm reading what the court said here.
And if I might call upon the 10th Circuit, I mean, the 10th Circuit has addressed this squarely. found that the directors, the Department of Labor, their interpretation of statute is not entitled to deference under Loper Bright. And that case is cited by me in the briefing. But that's the issue. There's no deference due to that regulation. This court can and should ask the Department of Labor what it thinks. And you know, the Department of Labor has previously indicated that the standard I advocate for today, the one adopted by Midland Coal, is the appropriate standard because it allows the ALJ.
So how different is it from the registration, what's put forth by the agency here? Doesn't it also focus on the dustiness, on the overground? Isn't it basically the same thing you arguing that the standard should be? Isn't that the regulation?
I wish it were, Your Honor, because in this case, the ALJ asks a single question, was it regular dust exposure? And in asking that question, the ALJ ignored.
But if we look at the legislative intent, that was what Congress was concerned with, the dust conditions.
Certainly, they're concerned with that, but they're also concerned with objective criteria, other factors that might be relevant to the circumstances of
I mean, I know
that.
that's your argument, but it seems as if Congress isn't less restrictive and that the legislative intent was to the benefit of the coal miner if there is any, based on this, the conditions of dust. I mean, and so I think your arguments are making it more restrictive as to what Congress's legislative intent. But if we look at the legislative history here, what you're saying expands way beyond what Congress has said.
No, Congress has said the conditions have to be substantially similar. Conditions, more than just was there regular dust exposure.
Well,
and the problem
you may have a really good argument on that. My suggestion is that substantially similar would be different from regularly exposed, because regularly exposed, you could be regularly exposed to only 1/4 of the amount of dust, and it would satisfy the regulation, whereas 1/4 would not be substantially similar. But my biggest problem is that you are presenting this to us for the first time, and there were factual findings that probably raised this to the level of substantially similar if that had been raised. You know, we have our decision in Potter where we didn't suggest that I don't think there's any suggestion of futility, but that was a more recent decision about whether you have to exhaust.
Right, and I think it would have been futile to make this argument. The administrative law judge, the Benefits Review Board, they would have all.
You may have had the deck stacked against you, but you still could have made it if you believed in it.
It did. The argument did not exist before Loper Bright.
Sure it did.
But
There's the two statutes. You can read the two, and regularly exposed, it doesn't. There's no quantity attached to that. So the regulation says you could be regularly exposed to 1/8 the dust, whereas the statute said it has to be similar to coal mine dust. Surface has to be similar to the underground mining. But the factual presentation in this case hurts you too, because there were real findings that he was exposed to a lot of dust while surface mining, not only at your company, but at his prior employment. And there's no evidence about his prior employment except his evidence, which was that he was exposed to this dust. He had to clean it up every day. It was lying around on the seat inside his cab, and they made factual findings on that. What troubles me the most is that we have no input from the board or the ALJ on this issue.
But we had continually challenged whether his coal mine employment is considered qualifying, whether it's substantially similar. So I want to make a distinction. The issue that Loper Bright brought to forefront was this legal issue that this court can address. There's a problem. I get it, Your Honor. You're referring to factual findings. The problem is the ALJ made such findings without considering probative, relevant evidence, dust sampling evidence that we put into the record.
Well, the board addressed that, didn't it?
The board said it was harmless error, Your Honor, to not have
Because you
considered
didn't
it.
address the employment at Summit, where there were 10 years of employment.
But the Mr. Culbertson had testified that his employment conditions were the same at Summit as they were at Extra Energy. We have relevant and probative dust sampling evidence showing the dust levels were 1/4 of the applicable permissible exposure level. So they were way below what is even what's considered the standard.
But I don't even, but see, this is what I'm saying. You are, this seems to be the test. Since we're considering conditions, you don't have to go consider the conditions here, there, and that's kind of, this seems like to be your arguments. The conditions at Extra Energy during the time that he was working, he testified to that. That's in the facts. You're saying, oh, the ALJ didn't consider this over here, or the conditions over here, and these conditions, and he testified to the conditions.
Except the ALJ ignored critical, relevant evidence that could have altered the outcome. That's prejudicial error. And that's the problem. The focus on, is there just regular dust exposure? If Mr. Culbertson testifies, he says yes, that's the end of it. And the standard I'm advocating has been in existence in the Seventh Circuit since 1988. It was previously the one that the director indicated was the reasonable approach. It's not onerous. It's straightforward. And it's the DOWCV Midland Coal Test. Under this prior standard, the coal miner has to offer sufficient evidence of the surface mining conditions in which he or she worked, and then it's the function of the administrative law judge, based on his or her expertise, and we would expect certain objective factors to compare surface mining conditions established by the evidence to those that prevail in underground coal mines, and then make a factual finding of substantial similarity. That is a straightforward application. As I said, Your Honor, it's been in existence since 1988. The director indicates in promulgating this new regulation, which is in effect narrow and invalid, that it's important that ALJs, administrative law judges, make specific factual findings as to substantial similarity. The ALJ didn't do that here. It just says, well, there's regular coal dust exposure. We identify dust sampling records that are objective evidence. We identify an article.
What standard did the ALJ use with respect to the dust? There was a lot of evidence about the coal mine dust. And what did the ALJ say with respect to that?
Just regular, there's the regular dust exposure. It meets the definition, or not the definition, but the concept of regular dust exposure, therefore substantial similarity. That's the analysis that the ALJ went into. The ALJ didn't consider that Mr. Culbertson works in enclosed cab, air conditioning, windows up.
Well, they had explanations for that. I mean, the air conditioning wasn't working a lot of the time. He left the windows open. The seals were not good. That's a non-starter in terms of factual aspects. You may have a good case for a fact finder, but the facts were found against you on that issue.
Without considering probative, reliable, credible evidence, and also while disregarding Mr. Culbertson's expert who testified under oath that, yeah, Mr. Culbertson likely had lesser exposure than would have been underground. That is not considered by this ALJ. Because the ALJ asks, is there regular exposure? The conclusion comes up yes, and that's the end. I see my time is.
Time's up. We'll get you on rebuttal.
Thank you.
All right. Ms. Petzock?
Thank you, Your Honors. My name is Sam Petzonk. I'm counsel for the respondent, Mr. Culbertson, Thomas Culbertson. This is I represented him in the underlying black lung application at the Department of Labor. It's a pretty standard federal black lung record. The ALJ made reasonable findings supporting.
Well, it's a standard record, but it's got a peculiar issue here. And the underlying point that the regulation applies the statute requires a notion of similarity, and the regulation would authorize exposure to 1/4 the amount of dust because it's regular, and there's no quantity aspect to that.
I understand.
So that's a problem, but I think there's several matters that you can say and do say in response to that issue, and I'm curious why, I'm curious on two questions, why it's not forfeited, that issue, and I'm also curious as to know why the ALJ left out their testing data.
I generally join the solicitor's arguments on those issues. I can address the second one. As to forfeiture, I would like to let the solicitor address that. I tend to agree with you. It wasn't raised. It could have been raised. They could have raised Chevron deference, in a Chevron argument below. They have also made assertions of error regarding the medical findings, and I took my position here today if you had questions about the medical evidence, certainly there was plenty substantial evidence to support the findings of impairment and causation of impairment. Those are some of the other assertions of error that were not addressed in the opening. But I can go to your question about the minor's testimony and the record regarding those dust samples. The minor testified, as you noted, Judge Niemeyer.
I do, but I want to know why the ALJ left out the employer's data. They had actual measurements, air measurements. Now, they may have not been good data or whatever, but what was the reason that they were excluded?
Well, I don't know that the ALJ excluded them, but an underground coal miner doesn't have to show that the mine violated the dust limit in order to demonstrate dust exposure underground, so I don't think that...
You're missing my question. The
Yes.
employer came in and tried to make a case that the surface mine exposure was not similar to underground exposure by showing data, measurements taken of the air outside and compared to measurements of the air inside.
I think the ALJ ignored those to the extent the ALJ didn't discuss or weigh them. They wouldn't be relevant to that assessment in an underground mine either, Your Honor, because simply because the mine doesn't violate the dust limit doesn't mean that there's no dust exposure. That you can develop black lung even if you work in a mine that isn't violating the dust limit.
Under the regulation, you could have a regular exposure to 1/4 or 1/8 of the dust that's in the underground, in which case it would not satisfy the statutory requirement of being substantially similar.
Well, that's where the testimony, the dust sampling doesn't get you there, is what I'm saying. It's not relevant. The fact there was no violation, there could be no violation underground too. It doesn't affect whether or not you had regular dust exposure. The probative testimony, the relevant testimony was the conditions that he worked in, which Mr. Culbertson addressed. You see what I'm saying? If the judge had looked at dust samples from an underground mine, they very well might have showed no violations as well. It doesn't affect whether there was actual dust exposure in the day-to-day work. Just because you work in an area where there are no dust samples that violate the limit doesn't mean you were not regularly exposed to dust. Those samples don't prove any point.
Is that what the ALJ said?
I don't know that the ALJ analyzed it that way.
Well, that's what I was asking you about.
Yeah, that's why it's not really probative or relevant, though, and shouldn't prejudice the results. I think that's what the board said as well.
The board based it on the fact that he had 10 years of exposure on which there were no data, and it was harmless.
And it was harmless that the ALJ didn't get into this kind of consideration, but really the evidence doesn't prove, the dust samples don't prove that he had no dust exposure. What goes to what he testified about how he encountered dust. And it's important also that in the record there was evidence that he had developed emphysema and COPD from his dust exposure. The agency, it gets to your question, Judge Niemeyer, the agency didn't even have a separate enforceable dust limit for silica dust at that time. Silica dust causes emphysema. The dust results here aren't relevant at all to whether he was exposed to silica dust, which is causative of the medical condition that he suffered from. So the fact that the mine didn't have coal dust, violations doesn't even begin to address the question as to whether this miner was or wasn't exposed to the silica dust, which causes the pulmonary emphysema. That was the basis of his disability. So again, it was harmless that the ALJ didn't get into the coal dust samples because the type of exposure the miner testified he had and the type of disease that he actually developed was consistent with another type of dust exposure, silica dust exposure, which is not addressed at all in the dust samples. Those dust samples are coal dust samples, not silica dust samples, so they don't get to the issue of whether he was exposed to the risk factors for emphysema, which he has. And so for those reasons, the ALJ didn't prejudice anybody by not exploring the coal dust samples. And I would also just emphasize that what is definitely not in contention here is that this minor has severe pulmonary impairment. All of the pulmonary function testing, even that was done by the coal company's doctor, showed that he had about 40% of his predicted lung function. So he's got serious impairment. He worked in the mines for 30 years. The only question is, did he have sufficient dust exposure to place him at risk for developing emphysema? And this is relevant because the silica dust is a significant risk factor for the emphysema. Coal dust samples don't go at all to the exposure to silica dust. He testified, I worked outside, I worked in an operation where, you're grinding sandstone and coal. Those are multiple dust exposures. He could very well have developed the emphysema from the sandstone dust exposure, from the, in the conditions he described in that cabin, working in the pit of the mine, was very dusty. And so there was plenty sufficient evidence based on his testimony, based on the type of emphysema, the type of pulmonary impairment that he had. His testimony fully supports a medical exposure predicate for that diagnosis. So there's no error from that standpoint. And if I cede the rest of my time to the solicitor, thank you.
Thank you. All right. Mr. Doyle?
May it please the court, I'm Michael Doyle. I'm here on behalf of the director, OWCP. Your Honors, I'd like to address the forfeiture issue first. In this court's decision in Ed Potter Cole, the court made clear that the intervening change in law exception to forfeiture is a very narrow exception that only applies when there's a direct precedent on point that makes a argument futile to be raised, and that wasn't the case here. Mr. Gregoracci says, well, this court's decision in Bender from 2015 foreclosed his ability to argue before the ALJ and the board that this regulation is invalid. But Bender clearly dealt with a different subsection of the regulation, which is at 718.305. Bender dealt with the rule-out standard, which is in subsection D, and here we're talking about the 15-year presumption, 305B2. So it's a completely different issue. Bender said nothing at all about how the presumption is supposed to work. In fact, Bender, the minor, was a underground miner, right? So he had the benefit of the 15 years without regard to substantial similarity. The term substantial similarity can't be found in Bender, right? So Bender is not a precedent from this court that would have foreclosed Extra Energy from raising that issue before the ALJ and the Benefits Review Board. With respect to Loper-Bright overruling Chevron deference, the notion that that would be an intervening change in the law is misguided, because both Chevron and Loper-Bright are about interpretive methodology, right? They don't tell courts how to address certain issues, except as to here's how we approach. If there's certain conditions met, Chevron held, well, the court should give controlling deference to the agency's interpretation. But that doesn't mean that, for example, that you can look at this statute and this regulation at Chevron and say, okay, the court is foreclosed from reaching any other conclusion, but that the statute is, that the regulation is valid, right? It's just about how a court is supposed to go about its task of statutory interpretation. That changed with Loper-Bright, but certainly nothing about Chevron foreclosed the argument that Extra Energy raises on appeal. I'll also note the irony, finally, that one of the arguments that Extra Energy makes is about Dr. Rosenberg's FEV1 FVC ratio. He raised that in the proceedings below, right? That issue had been foreclosed by I think in footnote 11 of my brief, I cite 11 or 12 different Court of Appeals cases directly dealing with that issue, saying that that Dr. Rosenberg's theory conflicts with the Department of Labor's approach, and yet they keep raising the same issue. So when we talk about futility, I think it's somewhat ironic they were able to raise that issue before the ALJ and the board, even though there's this mountain of Court of Appeals authority against them, but they couldn't raise this issue about the validity of the regulation. Now, with respect to the regulation itself, whether it is valid, we did detail the various things you look at. Under Loper Bright, you're now thinking about, is this the best reading of the statute? All right? Is regular exposure a legitimate proxy for substantial
Well,
similarity?
you heard my difficulty
Yes.
is regular exposure includes exposure to only say 1/4 or 1/8 of the dust in the underground mine. And you're regularly exposed to 1/8, and it would be hard for me to conclude that exposed to 1/8 on surface mines to what's exposed, the exposure in an underground mine would be substantially similar.
Yes, Your Honor.
It's not similar at all. It's dissimilar almost, but I would, if we had just had that regulation before us and it was preserved and everybody's fighting on it, I think that would be a tough case to address and a tough case for you to defend.
I don't think it's difficult to defend, Your Honor, and I think the reason for that is when you take into account the reasons for this presumption. The presumption is designed to make it easier for coal miners to
Oh, I
make
understand
their
all
case.
that, and it governs the presumption, but the question is, regardless of all the latitude, regularly exposed could be regularly exposed to roughly anything, whereas the statute requires there to be substantially similar conditions. And if you're regularly exposed to much lighter conditions, I don't think you could call that similar.
Well, then that invites the question of what's the comparator on the side of the underground coal mine, because you just said, well, it's 0.4, 0.8, or whatever, but there are coal mines throughout the United States, underground coal mines. They have varying levels of dust
Oh, yeah,
levels.
I understand that.
So-
As a factual matter, they can be, but I'm assuming that we know the facts, that there are 100 units of coal dust underground, and that there's only 12 units of coal dust on the surface mine. Now, it seems to me the surface mine work would not be, the conditions would not be similar to the underground in that hypothetical.
The problem with that hypothetical, there are several problems. One is the difficulty of proof.
Well, I understand. I mean, you have to, hypothetical supposes the fact.
Right.
Supposes the fact.
But
I
it's
mean,
still-
in this case, there was a lot of proof particular to this particular case. And the ALJ made findings and the board addressed them, so forth. But I'm just talking about the focusing on the regulation itself. I think there's some serious questions might be worth the director looking at.
You were about to give the problems with it, and your partner there gave some indication, because when you say substantially similar, we don't know what the similarity is, because you don't know what it is underground. I mean, if that's it, it's not a number comparison that 100 is even. 100 is something you just pull out of the air, but what were the points you were about to make in response to it? I'm really curious as to
Yes.
how you view this.
The difficulty is, remember, it's the claimant's burden of proof, all right? So you're asking a claimant to, number one, prove what the conditions are in underground mines, all right? And then you're asking the claimant to prove, let's say, okay, the evidence says at the mines in West Virginia, common exposure underground is, 0.5 or 1 or whatever, right? So now it's the claimant's burden to say that my conditions that I was exposed to on the surface were similar to 0.5 or to 1 or whatever when I was in the coal mines at Summit in 1996, right? How is he going to prove that? It would be impossible to prove that for a minor. And so that would make a,
But even there, would that also mean if you got to look at this particular underground, that this is different? It's this standard, this here is different depending on the mine? In every instance, you got to go and try to figure out what that particular one was, or, I mean, that's the confusing part that I'm
right,
trying
I
to
think
get at.
what is unanswered and what the Midland Coal Court was trying to address was, which mine, what's the comparator? And I think that.
Well, isn't that a criticism of Congress's selection of that? In other words, the impossibility to measure, I gather what both you and Judge Wynn are exploring is that each underground mine is different conditions, and you have to have the data, actual data, from this underground mining in order to determine whether the surface mining is substantially similar. And that proof is almost impossible for a claimant. That's your point.
That's my point.
But Congress did use substantially similar. And so the question is, how do you interpret that? Now, the agency has concluded that, well, regularly exposed is enough. But the problem with regularly exposed is you may be exposed to a minuscule amount of dust that is almost by common sense, not even close to what's in the underground mine, would still be covered. And I would think if you had a straight-on application of the reg, there might be some difficulties because it may be much broader than what Congress intended.
But before we blame Congress here, though, Your Honor, I would suggest that Congress used a broad term substantially similar to conditions in underground mines, knowing that that would be interpreted in a way that's consistent with the remedial purpose of the Black Lung Benefits Act, consistent with the fact that what we're trying to do here.
When there's interpretation, but we do have to follow the words, don't we?
Right, but substantial similar is enough play.
Substantially similar is a term that says it's similar, give or take,
Right.
plus or minus some level, and it seems the agency could certainly regulate that and increase that margin of similarity, but they still do use the word similar, which has a meaning. And the question in my mind is whether the regulation allows dissimilar conditions to suffice.
I think
and I think it would be helpful to modify the regulation
I will say,
generously.
Right.
Similarity has to be generously, or you can presume something that the mines have a certain level or whatever. I don't know, but
I will say,
as it sits now, it looks like an interpretive question, and my biggest difficulty is whether the employer raised it and presented it. But I do think there is an issue there at some point, don't you? A legitimate
it
issue.
sounds like there
You don't
will be,
need to
depending on who
confess.
the panel is on the
You're
next.
speaking on behalf of the director.
All I'll say is the preamble to the rulemaking does go through, in a thoughtful way, what the department was trying to do here. You do have Judge Cathledge's concurring opinion, which we like in a post-Chevron world, that the agency did the best it could with the language in a way
Do
that.
you agree that the statute does give the Secretary of Labor explicit authority to promulgate these regulations?
Yes, Your Honor, although I don't, with respect to this regulation, you see in our brief, we don't claim controlling deference in a post-Chevron world. We're not suggesting that this regulation is entitled to controlling deference. The reason for that is this is a interpretive rule that the department explicitly promulgated pursuant
Well,
to.
you use the term controlling deference. I'm not sure what that means. It seems that local right basically said, the courts have to interpret the statute. So I don't know what kind of deference we give controlling otherwise in general. But there is this provision in there that speaks to the fact that if Congress gives it somewhat explicit or to do these particular things, and it has to, because as Judge Niemeyer alluded to, Congress needs to fix it, but Congress can only fix so much, because Congress cannot be at every mine, cannot be on every case, and it is the Department of Labor that has the Secretary of Labor has some expertise, some knowledge, at least internally, what's going on there. And the question is, did it give, and maybe the type, I don't know if controlling matters, but it just says that this is different if Congress has given a secretary this authority.
I agree with that. We did claim Skidmore deference in our brief, Your Honor, based upon the agency's expertise.
Well, that authority would, of course, authorize the agency to fill all kinds of gaps, but I'm not sure that authority would ever authorize agency to do something in conflict with the statutory provision.
I think that's correct, Your Honor. My time is up.
All right, thank you very much. All right, we'll hear from Extra Energy.
Yes, thank you, Your Honors. On October 1st, 2025, this court published opinion, Hobart Mining Incorporated v. Director, Office of Workers' Compensation, said, quote, "Our interpretation of the Act and its regulations, however, involve questions of law. We do not defer to the board on legal issues. The question raised today about this regulation and how it conflicts directly with the statutory language of substantially similar is an appropriate legal issue for this court to address right now. It would not have mattered what the board or the administrative law judge has said, because this court has agreed there is no such deference to be given to the board on its interpretation of the statute." So that's a purely legal question. And there was some discussion about, well, how is the miner going to prove this or that as it relates to underground coal mines? The standard I've advocated for, which is the one that the Department of Labor agreed was the valid one in 1988, requires only that the miner produce sufficient evidence of the surface mining conditions. And then all the other nuance and the facts and the factors to be considered, the parties could rely on the expertise of the ALJ, and the parties could produce what evidence they believe is necessary. And in this case, the employer submitted relevant evidence that was disregarded and ignored by the administrative law judge. You know, the administrative law judge said that, as to the dust sampling evidence, "I find the document relevant to the question of coal mine dust exposure and therefore admissible. It is admitted into the record and will be weighed according to its relative probative value." You know what? That never happened. Do not excuse the clear prejudicial error, the ALJ failing to consider evidence the ALJ admitted was relevant and probative. There's a very simple, straightforward path in this case. You could vacate the finding of substantial similarity because the ALJ failed to consider relevant probative evidence that could have altered the outcome. Send this back, have the ALJ reconsider that issue in the evidence, and then make appropriate factual findings.
All right, thank you very much.
Thank you.
All right, we'll come down to Greek Council and take a short recess. You okay with this short recess? And take a short recess.
This honorable court will take a brief recess.
All right, proceed on the next case, which is Beltway Paving versus Pruco Life Insurance. And Ms. Gaines.
Yes, sir. May it please the court, my name is Eden Brown Gaines, and I'm representing Beltway Paving Incorporated. It's a
You're
pleasure.
gonna maybe pull the mic over, or you could just speak across the room. We're over here.
Okay, my children would never say I'm soft-spoken, but everyone else says that. So, I'm certain the court is familiar with the facts of this case, so with the court's permission, I'm going to dispense with the recitation of the facts and just address them as they're relevant to the argument. The district court, in its analysis, stated initially the standard for an unjust enrichment claim, indicating that the district court recognized this as an unjust enrichment claim against the estate. But after stating the standard, the opinion goes off the rails into a different direction that isn't what this case is about. And I think the district court's failure to understand that the premise of the claim is unjust enrichment concerning the estate, and instead looking to the contractual relationships and equitable adjustments between the insurance company and the parties was in and of
Wouldn't
itself.
they be one and the same if the insurance policy was held, it was required to make payment to the estate? In other words, if contractually, the insurance policy had to be paid to the estate, it's hard to argue that the estate then is unjustly enriched. The estate may not even known that it's coming, or it may have orchestrated it, but it seems to me you have to fall back at some point on the policy and say, did the policy require payment to the estate?
Not under the unjust enrichment context in the state of Maryland. I cited to Hill versus Cross Country Settlements in the briefing because I just think that's a good case in Maryland that not only enumerates the standard for unjust enrichment, but gives context to the purpose of an unjust enrichment claim in Maryland and explains in greater detail with respect to what unjust enrichment is really about. So the issue isn't really about whether or not the insurance company properly paid the proceeds to the estate. It's about...
Let's explore this, because this gets a little bit to the heart. If, set aside this case, if the insurance party clearly designated a person as the beneficiary of the policy, and the insurance company pays that policy to the person, what kind of case could be to deprive that person of the benefit of that contract? In other words, if the contract clearly said, this is going to go to Mrs. Smith, I've designated Mrs. Smith the beneficiary, I die, and the insurance company pays the policy to Mrs. Smith, and other families saying, oh, before he died, he promised this, he promised that, and so forth. And the insurance company said, policy said, I pay it to Ms. Smith. Now, the question is, how could we ever argue Ms. Smith's unjustly enriched if the policy authorized that, properly authorized that?
Because, for several reasons, Your Honor, because in an unjust enrichment claim, the focus isn't on the insurance company at all. It's not whether or not the insurance company properly paid the proceeds. The focus is, as you've noted, whether or not the estate properly retains the proceeds. And under unjust enrichment, the court said that the focus is whether or not the defendant should be deprived of benefits that in equity and in good conscience he ought not keep. That's Hill versus Cross Country Settlements.
Well, what is the basis for establishing that? I mean, yeah, the end result is what you just gave, but in order to get there, at least under Maryland law, as I understand it, and of course, you of course understand Maryland law better than I do, but under Maryland law, you've got to show that at some point in time, there was some effort by the beneficiary to change this policy. Is it more the person who's the beneficiary at the time he's living when Williams died?
Yes.
More the beneficiary. So it is more.
I'm sorry, Your Honor. It's Williams who is the beneficiary and Moore is the decedent.
William dies, then it's Moore.
That's correct. Yes, sir.
And the problem is when Moore dies, where does the policy go? Is that right?
Yes, Your Honor, that's correct, but that's all the contract discussion. That's a discussion of the contract claim between the parties and the insurance company. That focus...
But the opportunity to change the beneficiary, Judge Niemeyer has indicated the policy indicated as a specific beneficiary. You say that beneficiary shouldn't be that. The intent equitably was for it to go to Beltway. So who was to change the policy?
Whether or not the insurance policy got changed and whether or not the parties went through the proper steps to change it isn't really relevant to the
It's
unjust
not
enrichment.
relevant as to whether they made any effort whatsoever to change the beneficiary on a policy under Maryland law?
Not to the unjust enrichment claim.
Why is it not relevant? One of the things you have to prove on the unjust enrichment is that your argument is that Beltway paid for this policy, and so the benefit of the policy should go to Beltway. So how is it not relevant that the beneficiary is not changed on the policy by, I think it's Ms. Williams-Murphy?
Because the changing of the beneficiary, Your Honor, is subsumed within the concept of the contract law, the contract issue between the insurance company, the owner, and the insured. In an unjust enrichment claim, the court isn't to focus on the contract between the insured and the insurance company. It's supposed to focus on just the ultimate benefit
It
that got.
focuses on the fact that the recipient was unjustly enriched unjustly. But if the contract says that person's supposed to be benefited, then there's no unjust aspect about it. In other words, Moore and Williams, the 2017 policy was distinct from the 2015 policy, which had a rider, it was a key man type of policy. Here, these two partners who know each other well and work with each other just did a policy between the two of them. And whatever they did over golf, they say, well, let's give each other policies. Now, they used their business, but the two of them owned the whole business. They used their business to pay for the policy, but the two of them set it up, and Moore said, all right, Williams, I'm going to give you make you the beneficiary, and if you die before me, it'll come back to my estate. That's what the policy says. And so Moore died before. Policy says it now goes back to, Williams died before. It comes back to Moore's estate. And he dies a few months later. They all die together, I guess, somehow reason. But it went exactly as they specified. Now, the question is the recipient. You say it's unfair for the recipient to receive it, but the recipient received exactly what was legally designated to be received.
So two things on that to both your honors. Unjust enrichment is a quasi-contract theory. It's a theory for when a contract doesn't exist. So it doesn't make sense to talk about the insurance contract that does exist in an unjust enrichment stance. Unjust enrichment is supposed to focus on the parties who don't have a contract, which would be the estate and Beltway Paving in this case. It's a quasi-contract theory. You can't have a
The question, though, is really going to how do you get to that result? You're correct. That's the end of it. But the reason a contract is important is because you have this beneficiary. Take this example. You got Tim Moore there, and I guess it's within 8 months, he then dies after Williams. And that creates the problem, because then you say Beltway should get it. What if he waits 5 years and Tim Moore's name is still up there? You think you've been unjustly rich in all that 5 years or 10 years? In this instance, what is represented in the question here is whether has been, what you're alleging is that Moore intended for Beltway to be the recipient of this. But Maryland law requires that he took some steps to do something, and he did nothing. Even after getting the indication, he did absolutely nothing.
Respectfully, Your Honor, that is in the contract theory with the insurance company. You're correct on Maryland law with respect to whether the insurance company properly paid these proceeds. But when you're looking at the unjust enrichment theory, it's not about compensating the plaintiff, whether the insurance company broke the contract. It's about forcing the defendant to disgorge benefits that would be unjust for him to keep. The reason it's unjust for, I know you want to answer.
Why is it unjust for, why is it unjust for the estate to keep the benefits of the decedent, who the estate, why is that unjust? Because they didn't pay for the policy?
That's one of the factors, yes, ma'am.
Except these two guys could have been playing golf. They both own the business. They own it totally. They say, we're going to pay for the premiums, and whoever wins this golf game becomes the beneficiary, and I'll buy the policy. They entered into this policy 2 years after they did business policy, 2017, and it makes no mention of paving. They use their paving money to pay the premiums, but that's it. They designated one as a beneficiary, and then under the policy they got, it goes back to the other if it predeceases. And so the insurance company just follows the law and legally and obligation-wise pays it to the estate. Now, you say it's unfair for the state to receive something that the insurance company gave it?
That's correct. Put the insurance company...
Why shouldn't the insurance company have given it?
Because the insurance company giving it isn't relevant here. They didn't interplead. They actually made a decision and gave the money. So now the court needs to look into the funnel of the relationship between the estate and Beltway Paving. There's no contract, no
But
obligation.
wouldn't it be the relationship between the estate and Moore?
The-
You're saying Beltway because Beltway paid for it, but Moore is a member
Sure,
of Beltway.
sure.
He may have a minority interest in the company, but he's still a member he's still a member of the company, and and so wouldn't he have an interest in? I mean, Beltway. I understand you're saying Beltway the company paid it, but with him being a member of the company, wouldn't it be the relationship between Moore and his estate?
Sure, and the undisputed facts is that Moore did not intend for his estate to have this policy.
I'm not sure about that, because when they have this meeting on March of 2020, there's some conversation, I believe, about where Moore is saying, I don't want to make Beltway the beneficiary. That was the issue at the March 2020 meeting.
There was a dispute at that.
Yeah, they didn't agree. She wanted Beltway to be the beneficiary. He didn't agree to it.
No, ma'am, the email that's in the record makes clear what came out of that meeting. The email has a section that clearly says action items, and one of those action items was clearly to make sure that the policy that mistakenly identified Mr. Williams as the beneficiary
And what
was
happened?
changed to
Then the
Beltway
company
Paving.
said that action item was something alerting. He said he was just alerting them. And so he then sends 3 emails to see if they want to change anything, and there's no response.
They told them that they wanted to make sure that this was their insurance structure. They told them that they had a buy-sell agreement.
But there's no
that
decision had been made. The meeting, everybody, your client didn't even remember the meeting and didn't dispute what took place at the meeting, but the meeting, there was a disagreement as to how the policy was to be framed, and they hadn't resolved that yet.
No, sir. My
And then
client...
action item, or the agent came in and he said, he was at the meeting, testified, and he said, this needs to be taken care of.
Ms. Murphy was clear that before the meeting, there was an intent for Beltway Paving to be the beneficiary to ensure that Beltway Paving got that money in order to
Where does she get to say that?
because she's the CEO of the company, and she caused the company to pay all of the premium. She worked closely with Mr. Moore, who always expressed to her the intent that this is exactly what it was supposed to be. The meeting was fully about making sure that what was mistakenly done was corrected, and she understood her partner to be taking care of that, which she testified to consistently all along.
But
She
Mr.
continued-
Schubert testified that Moore and Murphy disagreed on the beneficiary because Moore wanted it to go to his family.
Mr. Schubert's testimony can't do more, Your Honor, than raise a genuine issue of material fact that would have caused this to go to trial, because if
But
you
there's
look...
no dispute about that.
There is a dispute. The email itself conflicts with what Mr. Schubert testified about. If you look at the email, it says action items. It says clearly that the beneficiary was to change to Beltway Paving, and it said action items. When it said action items under Mr. Moore, it was to make sure that this was effectuated. So I understand what Mr. Schubert said, but that is inconsistent with what he wrote in the time as a business record and sent to Beltway Paving. So
He
if the court...
said, and he also testified that the email that he sent to them was because of this disagreement, and these were just mere suggestions.
It says action items. That's different than a mere suggestion.
I'm
So-
just saying this is what he testified to in his deposition. Is that not correct?
It is correct, but what I'm saying is that that conflicts with what is in evidence. And so at worst, instead of granting summary judgment, the court should have recognized that if it was important
But he
as a
explained
genuine...
what he said there. He said it was an action item that they had to address. He didn't say it was a decision that had been made.
But it's clearly
And he
consistent.
explained that. He
It's-
said it had not been decided right?
That's right, Your Honor, but it's clearly consistent with Ms. Murphy's testimony that at all points, before that meeting and after that meeting, it was supposed to be corrected to reflect what was the intent of the parties. And so if we're going to believe
She
Ms.
didn't testify to any knowledge about the meeting.
her knowledge of the meeting isn't significant, because what she did testify to after the meeting is that her understanding that her partner was taking care of this, and he was going to make sure that this got changed and it was done correctly, which was why she continued to pay the insurance premium for Beltway Paving, because this was her understanding. It was all about being able to discharge their requirements under buy-sell agreements after death. She was consistent before this meeting and after the meeting. The fact that she did not attend the meeting is insignificant. I'm only saying that if the court found this to be significant, Mr. Schubert's testimony is clearly inconsistent with what he wrote, and at worst, the court would have had to have said there's
Well, I
a...
don't know if it's, and I'm looking at the document at JA 286, and he's, in here, he's saying from the conversation, Tim and Christine wanted $500,000 to go to their spouses directly, and for Beltway to have $2 million, and for Tim, $3 million, for Christine as a part of the buy. I mean, so there, he's indicating that there was some discussion about family members receiving part of this policy.
Yes, ma'am, but he's also indicating the discussion about changing it, because at the time, the way it looked with the beneficiaries is that there was only going to be $1 million to Beltway Paving on Mr. Moore's life, and it needed to be changed so that it would be $2 million. So you also see in that box that he wrote, where it does say recommendations, the subject insurance policy is changing that from Mr. Williams being the beneficiary to Beltway Paving. Then when you go down at the bottom of the chart and you look to action items, you see for Tim, it makes clear that the insurance is supposed to change from $1 million to $2 million, which means that it's going to have to be corrected, that Mr. Williams shouldn't be listed as the beneficiary, that it in fact should be Beltway Paving, and then that was the expectation. That was certainly the CEO's expectation. She doesn't recall the meeting, but she does recall that that was the expectation, that there was something wrong with the insurance the way it was indicated. When they got the insurance policy and she started paying the bill, she thought her father and partner had done things correctly. She had no idea until her partner brought it to her attention that there was an issue, that she was paying on a policy that was wrongly named for a beneficiary.
Well, does it make a difference that she didn't respond to the email?
The emails were for they were to both of them on the email, but it was her understanding that her partner was handling that. So she trusted that her partner had completed this information, completed what was necessary. She continued paying. She didn't stop paying for Beltway Paving because the intent was all along for it to still be Beltway Paving. So while Mr. Moore didn't do what she expected him to do, that was certainly her expectation. And it's that intent that is significant to an unjust enrichment claim, not a contract claim against the insurance company, but an unjust enrichment claim against the estate. Under Maryland law, is it fair, is it equitable for a windfall to happen? Should the estate be disgorged of the benefits? And in the Kowalski case that I placed in, understanding that it was a Florida case, that's exactly what that court considered. Not whether the insurance company had a contractual obligation to pay or not pay, not whether people changed the beneficiary or took steps, but exactly what happened here.
Well, that case is a lot different because in that case, they didn't know, the person did not know. Here is a little bit different because you have these emails, you have a meeting. I think that case is distinguishable from this situation.
Not in a relevant way, Your Honor, respectfully. I'm using my time, and I can come back and talk about that on rebuttal because I'm sure it's going to come up, but not in a relevant way. The court definitely looked to who paid the premiums and what the understanding was. And it was clear from the testimony here that Beltway Paving did have the understanding that they were paying these premiums because they thought it was going to be the beneficiary in order to discharge their buy-sell obligations.
Yeah, you got some rebuttal.
Okay, thank you.
Yeah. And Mr. Fong?
Good morning, Your Honors. May it please the Court. My name is Brian Donnelly. I represent Lisa Moore as personal representative of the estate of Timothy Moore. This case is about a failure of evidence. Beltway has alleged unjust enrichment because the estate of its deceased principal, Mr. Moore, received proceeds of an insurance policy that Beltway paid the premiums for. Now, to prove unjust enrichment, they need to prove three things, as the Court well knows. One, that a benefit was conferred on the estate. Two, the estate's knowledge of the benefit. And three, that the estate accepted the benefit under inequitable circumstances. And there's no dispute that the first two elements are satisfied. We all agree on that. But Beltway has not come forward with any admissible evidence of inequitable circumstances in this case. The policy language was clear. Beltway knew, at least as of March 2020, that it was not the beneficiary, and Beltway continued to pay the premiums on the policy with full knowledge that it was not the beneficiary. So exactly what was supposed to happen in this case happened. Now, by way of a preview, I'm going to go through just briefly some key facts. I'm going to discuss why this court should not adopt Beltway's reading of the
I
Kowalski
think we
case.
need to crystallize what the issue is in this case. Ms. Gaines has put forth rather forcefully that this is about inequity, and inequity in the sense that we focus on what is inequitable to do in this case. But there are questions under Maryland law in terms of what would establish the circumstances of it. And I think it'd be helpful to point to the Maryland law on it, the cases specifically to deal with insurance policies and how it. And while maybe Ms. Gaines doesn't think you ought to look at the beneficiary law on it, it seems to me, maybe you see it different and I want to hear it, Maryland law does take that as the basis upon which one works. That's why you get in this business of, well, the policy says this, the policy says that, and the beneficiary is that. That's not the end of the story under Maryland law. There's a case that can be made for an equitable remedy here, but there are components there that we should focus on, and not just general type information, but what Mr. Moore specifically did, because he's the beneficiary, and the question, or he has the policy, and the question is, how do you go about changing it? You can't just know someone has a policy with particular beneficiaries on it, but then have this belief, well, it is actually intended for this one as though it's a constructive sort of policy. You have to take some steps, and in certain cases, steps were taken where, the beneficiary or attempts were made to actually change it. They actually thought they were the beneficiary on the policy of things of that nature. They paid with that kind of understanding. So differentiate that, I think, which is the issue in this case is really the equitable relief one. And it turns on Maryland law. So focus us on Maryland law on that.
Thank you, Your Honor. And as the district court discussed at length, there's a line of cases, starting with the Urquhart case.
Pick your best one.
Well, I'll go with the Urquhart case, Your Honor. And there's essentially the same fact pattern, which is...
Which court of Maryland held this? This is the highest court of Maryland holding this.
I believe so, Your Honor.
Okay.
But the fact pattern's the same. There's someone who mistakenly believes that they were the beneficiary because they took all efforts in their power to change the beneficiary, and because of something outside their control, it didn't happen. And in those cases, the court has said, as a matter of equity, we're going to, equitably make them the beneficiary because not only did they think they were, but they took affirmative actions to try to make themselves the beneficiary. Not just any affirmative actions, all actions within their power. And this case is completely distinct from that, Your Honor. One, the evidence is clear in the record that nobody took any actions to change the beneficiary. Two, the focus on the Maryland case law is...
And what sort of actions are you referring to? What if he just intended it, or it was understood that that's what you were holding it for?
It's not enough, Your Honor. Maryland law...
It kind of reminds me of establishing a constructive trust type situation. You don't actually have to, you inform this is what this is for, and yet you maintain it, but you know what it is for, all the parties do.
I think under that hypothetical, Your Honor, it still doesn't apply to this case because Ms. Murphy knew full well that Beltway was not the beneficiary at the time. And I'd submit, Your Honor, that even assuming what she says is true, which we dispute, that Mr. Moore told her he was going to change it, 8 months went by. There's some obligation on Ms. Murphy to take a step to confirm that what she thinks is being changed is being changed. She took absolutely no action. She ignored 3 emails from the insurance agents to follow up on what were clearly recommended changes. Language is very clear in that email, recommended changes.
Is it for or against her that she paid the premiums on this knowing that he was the beneficiary?
It's against their argument, Your Honor.
It's different than the Kowalski case out of Florida. I take it which
Yes,
was
Your Honor,
different.
in the Kowalski case, Ms. Kowalski continued making payments under the mistaken belief that she was the beneficiary. In this case, the record is crystal clear that Ms. Murphy knew, at least as of March 2020, that Beltway was not the beneficiary. And she made payments with that knowledge that someone else, specifically the estate, was the beneficiary. So I agree with Judge Benjamin, this is distinguishable from Kowalski. I also, would agree with the district court that the Maryland law is very clear that it's not just whether Ms. Murphy took any actions, it's the owner of the policy who has to take the actions, and it's also very clear on the record that Mr. Moore didn't take any action to try to change the policy.
Does the competing testimony, I guess it's Mr. Schubert and Ms. Williams-Murphy, about what happened at the March, I mean, she says she didn't remember it, but what happened at the March 2020 meeting, does that create a genuine issue of fact?
It doesn't, Your Honor, because as Your Honor just noted, Ms. Murphy doesn't remember the meeting even happened. She's simply not competent to testify about what happened at that meeting. She has no personal knowledge. There were 4 people at that meeting. Mr. Moore, Ms. Murphy, Mr. Schubert, and Ms. Warfield. Mr. Schubert and Ms. Warfield were both insurance agents. Mr. Moore is deceased. He can't talk about what happened at the meeting. Ms. Murphy doesn't remember what happened at the meeting. She can't talk about it. The only 2 that can talk about it are Mr. Schubert and Ms. Warfield, and they both unequivocally testified at deposition that no instruction was given at that meeting to change the beneficiary of this policy.
What about the email? Does that create a genuine issue of fact?
No, Your Honor, and that's, I think the only piece of evidence that they're actually relying on is this email. Mr. Schubert testified that email was intended to memorialize what happened at the March 5th meeting. He testified from personal knowledge that it was not intended to document decisions that had already been made, and I think the email is very clear in the first paragraph what its purpose was. It says he's going to summarize current policies, which he did, and give recommended changes. And then he goes on to state, Ms. Gaines made a lot of the action items he states. Those were specifically listed as action items for Mr. Moore and for Ms. Murphy, action items they had to take. And then he goes beyond that. He says, I will call to discuss. He reached out to them several times with no response. I think if language means anything, no reasonable juror could look at that email and find based on it that anyone instructed Mr. Schubert to make changes to a policy during this March 5th meeting, which is not supported by the record. To the contrary, the email shows what are 2 key facts in this case. One, that Beltway was in fact on notice that it was not the beneficiary as of March 5th, 2020, at least as of that date. And 2, Beltway would have to take actual actions to change a beneficiary, or Mr. Moore or Beltway. And none of those things happened.
Well, he testified a little more fully that at the meeting, all parties recognized that Moore was the beneficiary and his estate was, and that they understood that. And Moore and Murphy had a disagreement as to who should be. And he said they needed to make a decision on that. He recommended that Paving be the beneficiary, but they had to let him know. And he sent that email to both Moore and Murphy, and neither one responded.
That's right, Your Honor.
And then in that state of affairs, Moore dies.
That's right, and it's even more than that. He testified that at that meeting, they could not agree on who the new beneficiary should be. And Beltway Paving was not one of the 2 options they were disagreeing on. It was Mr. Moore wanted his wife to be the beneficiary, and Ms. Murphy wanted herself and her brother to be the beneficiary. So it's not even consistent with Beltway's theory that Beltway was even under discussion to be the beneficiary of this policy. I only have a couple minutes left, Your Honor, before I turn it over to Ms. Carroll. I want to just briefly spend a moment on the estate's alternative argument, which was that Beltway's claim in this case was waived. Beltway has maintained throughout this case that the whole purpose of these insurance policies was to fund buy-sell obligations under a stockholders agreement. In other words, if a principal died, These insurance policies would, provide Beltway with a source of funds to pay the estate to buy that person's stock. While this lawsuit was pending, the parties, in fact, entered into an agreement under which Beltway redeemed Mr. Moore's stock from his estate. And as part of that agreement, there was a waiver provision that waived the estate from all liability against Beltway relating to the stockholders' agreement or Mr. Moore's employment with the company. If Beltway is correct that the whole purpose of this insurance arrangement was to fund the stockholder obligations, then that waiver must apply to Beltway's claim in this case. It's all related. At this point, unless the court has other questions, I'm going to cede the podium.
May it please the court. My name is Christina Carroll of Denton's U.S. LLP, here on behalf of Pruco Insurance Company. Regardless of the claim for unjust enrichment, Beltway admits in its opening brief on page 4, and then again here today, that the focus of Beltway's claim is its unjust enrichment claim against the estate only, and whether it was inequitable for the estate to retain.
Let me ask you just something
Yes.
fundamental. Is there a claim that a claim against Pruco?
Yes, Your Honor, I was about to address that. I'm happy to address that. We don't understand what the claim is, frankly, against Pruco. The case started out as solely against Pruco as a declaratory judgment action, no breach of contract, no error and omission claim, no negligence claim, seeking a declaration that Beltway was the correct beneficiary under the 2017 policy, or that Williams was named in error. There was then...
It seems that maybe the insurance company, before you just paid out $1 million, would want to have a declaratory judgment indicating, once you know, or at least I guess have some notice that someone else is claiming to be the beneficiary. I mean, you paid the way the policy said pay it, but once you do that, I guess the question becomes, should you have done that, or should you ask? I don't know how that works.
I'd be happy to answer your question, Judge Wynn. When Pruco received in November 2020 the letter...
But I want to also follow up just to ask, because I'm curious. I mean, if there's $1 million out there, you've already paid it out, and if they don't have it, I guess the idea is you should have paid it to us, but it's too late. You've already paid it.
Right, but that claim was not asserted. Frankly, the claim was never amended. It was never amended in terms of, well, we would respond and say that if the insurance company does not have the proceeds anymore, and there's no breach of contract claim, no error and omission claim, no filling out the forms improperly, something of that nature, then what is the claim? And there would be no response in the briefing, as you'll see in the record, either at the motion to dismiss stage, judgment on the pleadings, or even now in summary judgment, where it just basically says a declaratory judgment would be nice for clarity and finality. As to your question about...
It seems to me a declaratory judgment is usually the backside of a breach of contract claim, but they do not assert, and she confessed that this is not a breach of contract claim.
Correct. Normally a declaratory judgment action in the insurance context would be like whether there's coverage. Does an exclusion apply? What does the provision apply? Hand in hand. But that's been abandoned.
Back to Judge Niemeyer's first question, what is your role here? I mean, unjust enrichment wouldn't prevail against you, would it?
Correct. That's why, regardless of...
Unless the other side is seeking some form of contribution, indemnity. I mean, how are you in this case is what I'm...
We don't know. We would like to not be in this case, but thank you.
But you got 8 minutes of it.
Yes.
That's what I'm trying to understand. You got a substantial amount of this argument for an entity that the real issue in this case deals with unjust enrichment, and yet we're talking about whether you paid something on a policy to a beneficiary that's right there on the policy, and now, and as I understand it, no direct claim is made for breach of contract or failure to do something.
Yes, we're happy.
Why are you?
We're happy to cede our time and just answer your question on the...
I'm not talking about happy to cede time. I just want to know why you're here. I'm trying to understand it.
We would also like to know why we're here. Yes.
But you're the one here.
We have to respond
You're trying
to the
to
claim.
eliminate risk, aren't you?
We're trying to eliminate risk on the claim and to answer any questions.
What would be the risk?
We're still named, there's still the claim that's through like a declaratory judgment, and we're not sure for what. It's harder to respond to sort of the amorphous than it is to the concrete. I can tell you that the insurance company paid pursuant to the policy, because that's what it's supposed to do. It did not.
You are named, and what is the allegation against you?
It's been a moving target in every pleading and brief. So we'd say that there's no, to
I'm
clarify
thinking at
that,
the trial level, because we review the orders of the trial level insofar as you. How was it dismissed as to you?
it's dismissed as a moot point. At the end, it's dismissed as a moot point because there, no unjust enrichment was found as to the estate, which I would sort of correspond to Judge Benjamin's earlier statement this morning, and saying of how can there be unjust enrichment when it was paid correctly according to the policy, and the two going hand in hand. That is the path the district court took. It's a potential path to take and a correct path, and we would request affirmance. But independently, my argument is that independently of this novel unjust enrichment claim that's unmoored from standards as to inequitable circumstances under Maryland law, regardless of what the Fourth Circuit were to conclude on that, as to Pruko, there's no claim stated. There's no case in controversy stated at this point, given it does not have the proceeds.
So even if they prevail on the unjust enrichment, you're saying there's nothing happening
Correct.
to you?
Well, yeah, you sound like you're in a pretty good position.
I'm trying to understand. Do you want to now convince us otherwise?
No, I know when to read the room.
Here.
If you don't have any other questions, Your Honors.
Thank you.
Thank you.
All right, we have, I guess Ms. Gaines has some rebuttal.
Yes, sir. Your Honors, the reason that we put in the Kowalski case is to kind of move us. What's been discussed, what the lower court discussed, is what's typical in insurance cases. This is a unique.
Let me just cut through this, and I think I'm trying now to rise above any of the discussions and see what the issue is. I think what the issue is that there has to be an attempt, some steps taken to change a beneficiary, clear intent and some attempts, and it was interrupted. Those clear attempts to change the beneficiary were interrupted by death. And in those circumstances, cases have given equitable benefit to that attempt. And the question is that circumstance been presented in this case?
No, that has not been presented in this case. And that's why we use the Kowalski case, because that court, the Southern District of Florida, got what we are asserting.
I understand that answer. I think Judge Niemeyer, sounds like to me he walked through your case and said that in this particular case, you have to establish that there was some intent to change the beneficiary, and that gives you equitable relief if you're able to do that, and so that he took reasonable steps to do it. And then he asked, has that been done in this case? You said no. No steps whatsoever did Moore take to change the beneficiary. No steps whatsoever was there to reasonably do. Didn't even intend to change the beneficiary. Is that true?
No, sir, I'm not saying that. That is not true. What I'm saying is that the equitable issue that the court below raised, and what the court is talking about here, is based on the contract claim with the insurance company. That's not what's happening here with the estate. It's not about the contract claim with the insurance company. It isn't true.
The fundamental point is that if there isn't some way to get the contract in line with inequitable distribution, which would be to change the beneficiary, in the absence of that kind of evidence, the insurance company is paying a benefit perfectly, obliged to make to the estate. That was the only beneficiary, and the only way, and that eliminates any unjust enrichment because it was legal, it was no deception. The question you have to demonstrate, and that's what I was trying to get you to focus on, is that you have to demonstrate that the beneficiary on the policy really inequitably should have been changed because of a clear intent and steps taken. And in the absence of a clear intent and steps taken, the policy governs and there can't be any unjust enrichment. That's what I thought the issue was, and it seems to me that's the only legal basis for an issue.
Respectfully, Your Honor, it's not. what I'm trying to get the court to move away from is the typical insurance rubric that we're discussing here. This isn't, that the equitable relief that the court was talking about is about, can we equitably change a contract based on these issues? Did they intend to change the
That's where
beneficiary?
the money came from.
But that's not the issue. It's not about whether we can equitably change the insurance contract. I used Kowalski because that court got what we're saying. That's
But
the
that,
issue.
that case is different because there, Kowalski was paying and thought that they were the beneficiary, and there was no other evidence to say that they were not. Here, Ms. Murphy knew that she was not the beneficiary. That was the whole purpose of the meeting in March. That was the whole purpose of the email that came back, was because she knew that at that point, we know that she knew in March of 2020, regardless if she can remember the meeting, she got this email. The email confirms that she was not the beneficiary. That's not the case in Kowalski. The reason because Kowalski continued to pay the premium under the impression that Kowalski was the beneficiary. That's not the case here. She knew she wasn't the beneficiary. Even if she can't remember the meeting, she's acknowledging the email, and in the email it's discussing that she is not the beneficiary.
At that point in March, but the court has to look at what happened after that meeting in March. After that meeting in March, I don't know how we can look at the email and say unequivocally that it came out that they weren't sure what to do. That email clearly says that the policy was to change to Beltway paving, and it says for Tim's
It
policies.
simply doesn't say
It
that,
just-
number one. And number two, he testified that the issue was not resolved at the meeting, and he was making recommendations, and his recommendation was that not even what was discussed, that paving be made the beneficiary.
Your Honor,
And then he asked him to make a change, but the person you have to focus on is Moore. He's the only one that could have made the change. And he never there's no evidence he ever intended to make a change.
Your Honor, for a breach of contract claim against the insurance
no,
company,
for
he
equitable
needed to make a
claim.
change. And to equitably adjust that contract with the insurance company, he needed to make a change.
The only
But
way, just a minute, the only way Murphy could claim the benefit of this, or paving could claim the benefit, is if Moore intended to change. Because Moore was the owner of the policy, he paid it, he used the paving money to pay for it, but he was the owner of the policy, he designated the beneficiary, and he became the beneficiary, his estate.
And the facts show he
and
intended to change it.
And he never, he expressed an intent to change the beneficiary at that meeting, but it was to his wife.
And
Murphy intended to change the beneficiary to she and her brother.
Your Honor, but the email also shows that both parties.
And the agent was at the meeting, and he recommended that the paving. But the point is, you have three different possibilities for beneficiaries, and nobody made a decision or request. And the insurance company asked for a request and never got it.
Your Honor, respectfully, the intent was to change it. The email shows they intended to change it. Ms. Murphy testified that after that period, they intended to change it. She continued to pay the premiums because she thought that, in fact, it had been changed. She made a claim under the policy because she thought that it had been changed. Under Maryland law, the defendant who has received money from the plaintiff, even if it's by mistake, even though the
Who wrote
mistake
the
is an
email?
honest one.
Who sent the email?
The email was sent by Craig Schubert, but the email
Do
is.
you have anything from Mr. Moore indicating he intended to do it? What is the
Yes,
evidence that Mr. Moore said he intends to do this?
Ms.
or made
Murphy's,
steps?
I'm sorry, Your Honor, I didn't mean to interrupt you.
Go
Ms.
ahead.
Murphy's testimony, she made clear that even after that meeting, Mr. Moore indicated he was going to make sure that those changes were
You have the hearsay
effectuated.
testimony of Ms. Murphy. What I want to know is, what is the testimony of, where is the evidence of Moore actually doing something? Did he submit that form?
For an unjust enrichment claim, we don't need the evidence that he actually
Well,
submitted the
answer my
form.
question, and I'll let you know about
Yes,
the
sir.
unjust enrichment claim. He never submitted the form. He could have, and he never took any steps in those 8 months to do anything himself. You have other people who now say he intended, he could have done, that sort of thing. I don't know, maybe that's admissible or not. I mean, if particularly once a person is gone, and, maybe it's a statement of interest in some instances or not, but the question here is, what did Mr. Moore do? In that email, he didn't write.
Your Honor, Mr. Moore did not actually make the steps to change the policy. That would be a relevant fact if this were a breach of
Let me hear
contract
that
claim.
again. You said.
Yes,
Mr.
sir, he
Moore
absolutely didn't.
Made no steps.
I
to
didn't say no
change-
steps.
But he did not make the steps to change the
He
policy.
didn't fill out a form and say, I want the beneficiary to change.
Did he
There's
make
no
any-
evidence
did he
that
do any steps at all?
Yes, sir, he
What
had
did
this
he do?
meeting. You can see from the email that they had a meeting where it says that
He never
those.
instructed Schubert to change.
Okay, well, he asked me if he made any steps. Any is a
Any
big
steps,
word,
right.
and having the meeting, telling your CEO.
Yeah, but the
telling them-
steps that he made is consistent with Mr. Schubert's testimony, because then why is Mr. Schubert discussing money going to Moore's wife
That
in the email?
That email, Your Honor, is inconsistent with the testimony to the extent it suggests that they didn't want this subject policy to change to Beltway paving. You can see from the email that there was a discussion of it. Mr. Schubert's testimony is that they fought about it. On that email, it says, with respect to this policy, that Beltway paving should be the beneficiary. Then it said, under action items, when there's testimony that they wanted $2 million, it's clear on that email that there was a discussion that Tim was supposed to make sure there was $2 million for Beltway paving, and it was to come from this subject policy. So that's clear. Mr. Schubert's testimony on that fact is actually inconsistent with this email and this business
All right,
record.
I think we've heard this.
Okay.
We're through this. Thank you for this.
All right, thank you.
Thank you, Your
We've
Honor.
extended the time, and
Thank you.
we'll
Thank you.
adjourn court for the day. There's no further argument, is no.
You got another case you might want to hear.
I might want to hear the last case. All right, thank you. We'll come down and greet counsel.
I think you-
It's all right. It's been a long day.
I'm going to go on to the last case, Crouch versus Sun Cakes, and Mr. Fong, whenever you're ready, we'll hear from you. Well, I thought we'd gone on pretty long on the other case, and that maybe it was time to adjourn, but we do have this, your case.
a little bit
So
first.
we'll hear it fully.
A little bit first, all right. Your Honors, may it please the court, my name is Wilson Fong. I represent Ms. Juanita Crouch the plaintiff appellant in this case. In an employment discrimination case, the plaintiff's testimony is enough to support their claims on summary judgment. The burden then shifts to the defendant to produce evidence of a legitimate non-discriminatory reason. It's then the role of the jury to decide who to believe. But what happens when the defendant fails to produce any evidence? The plaintiff should be entitled to an adverse inference, and summary judgment should be denied. The
Wouldn't
defendant's-
that be then you have as a burden in this case, then you have the burden to do depositions, seek affidavits.
The defendant has, or the plaintiff has the initial burden to, however, so that question has a couple questions inside of it. First question is plaintiff's testimony enough? When this court has said that, yes, plaintiff's testimony is enough to survive summary judgment in Williams versus Giant Foods, when that testimony is testimony about facts rather than opinions. Now, what Ms. Crouch testified to, he told me, can we go back to my house and fuck? That's a fact, right? That's not an opinion that she's coming up with. That's a fact. That's the thing that was said to her that gives rise to a sexual harassment claim. The second question about whether we have obligation to do depositions on. In the first place, my client is IFP. She can't afford depositions. We did take advantage of the discovery tools available to us through the rules of civil procedure. We asked interrogatories. We requested records. Defendant's answer to our question of who terminated Ms. Crouch was, I don't know. They gave a guess That was the operating guess, I suppose, for the duration of discovery. And then a month after the end of discovery, and 2 days before they filed summary judgment, they changed their guess.
They did add a little bit to that, I believe, and you can correct me if I'm wrong, but I think they said that the only person with the authority was the store manager, and that the store manager was so-and-so, and that the store manager was at work on the date that the plaintiff was fired. They put that information in, didn't they?
They added that information in that final discovery response 2 days before filing summary judgment, but there's some issues with that. The first is that nowhere in their policy does it say that a supervisor can't terminate somebody.
They said so. They said the supervisor, he may be able to discipline, but they say hire and fire, only the manager could do that. They said that, and there's nothing to contradict that. And they identified the manager at that time, and they also pointed out that the manager was clocked in for work on that day, on the day she was fired.
The records that they produce about what their policy is, which level of supervisor manager can do what, don't actually speak to any of that. The issue of the supervisor being actually clocked in on that day, there's two issues with that. The first is that the records that they produce of their time and the schedule don't really seem to line up. And they don't just line up in a way that shows that my client was absent excessively. They also line up in a way that shows that my client was at work when she wasn't scheduled to be at work quite a lot. And there's not really any explanation for that.
Well, they did show that beginning in January, your client was scheduled for 8 different shifts and appeared at none. And that oftentimes she came throughout her whole employment, including the fall, she came in late or didn't show up. And they assert that based on her attendance practices, she was fired. And so now the question is whether that's a pretext. The burden then comes back to you to demonstrate that was wrong, right?
Your Honor,
under the law.
We haven't gotten there yet. So,
well, that's my question is, am I right on that?
No, Your Honor, not quite yet. So, to begin with,
Well, it depends on which claim you're talking about. You're there yet. Whichever one are you talking about retaliation, or talking about Title VII retaliation, or are we talking about sexual harassment? I mean, it's the hostile work environment or whatever. And I think to answer Judge Niemeyer's question, you really need to identify which of the claims you're talking about. There's a different type of proof and different stance for each one. I mean, you got 6 of them here. Frankly, I think the only one, frankly, the one I'd like to hear about is the hostile work environment. I think you have a hard road to hoe on the others. That's just my opinion. It may not be anybody else's, but I'm just saying, if you're going in the direction you're going now in terms of retaliation or claims, that's a more difficult road, I think. But you can convince me otherwise. I'll leave that open. But I was in a position, I spend my time on hostile work environment, but I'm not you.
right, and so that's sort of why I'm saying we're not there yet. So the burden shifting, obviously, we make our prima facie case, they proffer their legitimate non-discriminatory reason, and then we're at the pretext stage. The problem is there's no contemporary evidence of their legitimate non-discriminatory reason. You're taking their schedule and their schedule and their clock report at face value when there's this weird discrepancy where she's coming to work and working full shifts on days she's not on the schedule. That can tell us a couple of things.
What about the text messages? What about the text messages?
Which text
There's a
message?
ton of them where she's late for work, she didn't come to work, she's, for whatever reasons, and there are these text messages back and forth, interestingly, between her and the guy that she said that made the inappropriate comments to her, the general manager.
So one thing I want to make sure you're
Because
not
you're
conflating-
saying there's something weird about that she's working when she's not. There's some, you're questioning, I guess, the timesheets. But those text messages clearly show that she's like missing work and late for work and asking, have you fired me yet? Because I didn't come to work.
Right, and that's the next part of that, which is that contemporaneously, it doesn't seem to have mattered all that much to the defendant at the time, right? The issue is,
Oh, no, in one of the text messages, he says there's a corrective action that you have to sign.
right.
And if you miss, and then there's another text message that says you have, that this is your last step or something like this, the next step is termination. So they're not saying, oh, just don't come to work or don't. And the text messages that they're sending is like, where are you? What, you were supposed to be to work at 4 o'clock. And you can see on the text messages is like 4:05, and she's like, oh yeah, I'm on the way, I overslept, or so I'm not sure you're trying to say that there's some discrepancy with the timesheets, but those text messages seem to corroborate that she has some issues with being absent and also being late for work.
Yeah, I'm not denying that she had some issues with absenteeism. The question is, was that the actual reason that she was terminated, right? There was a corrective action. There was one, and on that corrective action, it indicates a 3-step process. There's no step 2 or 3. So contemporaneous evidence doesn't show that that was the reason that she was fired. The first time she was fired for absenteeism appears years later in a response to the EEOC. She wasn't told why she was terminated when she was terminated. There's nobody in the record who says, yeah, I terminated her and this is why. And that's the important thing, is we asked who terminated her. Because the point of all of these claims, the point of any discrimination claim is intent, right? In order to know the intent of the decision maker, you have to know who the decision maker is. If we don't know who the decision maker is, we can't know who the intent is. And at that point, they fail to meet their admittedly very low burden of providing some evidence to support their legitimate non-discriminatory reason. Because we don't know who did it, we don't know why they did it. On the other hand, we have my client who was subjected to this sexual harassment, who testified to it specifically. They have no testimony back to the hostile work environment claim. She testified to what happened to her. The district court seemed to agree that that was sexual harassment, but they disbelieved her because her testimony was self-serving. Even the Eastern, I think it's the Eastern District of Virginia case that the court below relied on, acknowledges that this stuff's mostly going to happen away from other people. It's going to be a he said, she said kind of situation. We have what she said. We don't have what he said. There's not even an affidavit from Sean Edwards, the man who sexually harassed her, saying, I didn't do that.
Well, and the problem is because you have the burden and you haven't sought any affidavits or didn't do any depositions. So what, I mean, in trying to prove a prima facie case, what are we supposed to do with that if you don't, I mean, I understand your issue with her not financially being able to do, but she has to prosecute the case, and it simply seems like, to me at least, that she has not done that. I mean, even seeking affidavits to support what she's saying.
Who is she going to seek an affidavit from? We can't seek an affidavit from.
Well, that's why you have to do depositions. I mean, I understand.
Which we can't afford. So then.
But you got to prosecute the case.
I have. I asked the discovery questions.
Did you
Their
take the
response-
deposition of the manager, store manager?
No, Your Honor, couldn't afford to.
Well.
In addition to not being.
The fact that your client couldn't afford to do some discovery doesn't relieve you of the burdens in the litigation if you're going to pursue the litigation.
Well, 2 responses to that. In the first place, holding holding the plaintiff who cannot afford it to a responsibility to engage in all forms of discovery that she cannot afford is flatly unfair. But we did engage with the discovery tools that are available to us through the rules of procedure. The response we got was, "I don't know," from the defendant, right? So let's take that down. Let's say we did have the money to depose. We would have deposed their first answer, who was this James fellow that we don't know who he is. We go through all the trouble of deposing him, and we find out that he doesn't know anything. Then what? Then my client, who can barely feed herself, has now spent $1,000 deposing somebody who doesn't know anything because defendant couldn't be bothered to ask its own employees what happened. And that's the core of why I cite to Alexander, the Supreme Court's decision in Alexander, is that who terminated the plaintiff and why is information that is uniquely within the defendant's control, because they're the one who took the action, that they should easily be able to provide when asked, and they didn't. And that should entitle us to an adverse inference, because, again, this is something that is uniquely within their control, that they should be able to give to us, that they should want to give to us, assuming that it is in their favor, but they didn't, right? And that's the underlying basis for that line of cases, for the rationale there is, this is something they should want in the record. They should want their evidence that Sean Edwards didn't do this, that somebody else did it, in the record. But it's not. They didn't produce it. We asked for it and they didn't produce it. Quickly, before I run out of time here, I want to turn to the FLSA claim. The first thing, the court below decided res judicata barred that claim. I want to quickly note that the defendant did not raise that in their responsive pleading according to Rule 8, and so that should not be an issue. Res judicata shouldn't bar it. Second, under the dual jobs rule in the FLSA, a employer can't take a tip credit for non-tipped work which is unrelated to the tipped occupation. To be clear, it doesn't matter whether the employee made minimum wage including tips. What matters is whether or not the employer can credit those tips towards its minimum wage obligations. If it can't, it has to pay minimum wage for the time spent doing that job, regardless of the tips. There's no binding authority either way on what exactly is related or unrelated duties. But, and the binding authority does admit that, in other areas admit that it's going to be a judgment call for the court. But there's at least two other courts that have found that servers and hostesses are separate jobs. That's Bowe versus HJ and O'Neill versus Den, Ohio, which are both district court cases out of different states that are out of the circuit. But they're similar because those were both Denny's purchases, and Denny's is not so different than IHOP. The duties are not so different, and the differences are not so different. So it's clear here that these were different jobs because my client, in order to do the hostessing work, she had to leave the dining area. She couldn't serve people while she was doing it. And most importantly, during the day, the defendant hired a separate person to do this job, who they paid more than minimum wage. So defendant knew that this was a minimum wage plus job that they could not take a tip credit on. Nevertheless, they made my client spend half, sometimes more than half of her shift doing this job. And that last fact is also why the 3-year statute of limitations applies. So not only did Ms. Crouch repeatedly tell them that they have to pay her minimum wage to do the hostess work, the defendant knew that it was actually a separate job. And a violation is willful and subject to the 3-year statute of limitations if the employer knew that they were violating the FLSA. The defendant knew it couldn't take a tip credit, but did so anyway. The court below should be overturned and summary judgment should be denied. Thank you, Your Honors.
All right, thank you. Ms. Jones?
Thank you. May it please the court, my name is Lori Jones, and I represent the defendant appellee in this matter. I'd like to start off by discussing the adverse inference cases that opposing counsel brought up, because I think that those cases have been misapplied in this context. The plaintiff has argued that because we can't specifically identify who terminated his client, that he's entitled to an adverse inference that she was terminated for discriminatory or retaliatory reasons. He cites to Alexander and to one other case. So Alexander is a redistricting case. It involved a congressional map. The challengers in that case did not come forward with an alternative map showing a better racial balance, which case law in redistricting area says you've got to do this. This is an important thing if we're going to be considering whether a map is correct or not. And the court in that case even stated that any expert, and this is a direct quote, can churn out a map. So it was something that could easily be produced and it was easily obtainable. That is very different from this case when what they're asking us for is after the fact for us to give them an answer to a question that we don't have. And I think that it's important to understand the timeline here. Ms. Crouch, the plaintiff, filed her EEOC claim 5/31/22. At that point in time, Audra Causey, the general manager that you see her name in all the briefs, and Sean Edwards were no longer employed by my client. So there was no one, we could not go to them to specifically say, what did you do here? Who made the specific decision? What we do know is that the decision was made and entered into the computer on 1/12/2022. We know that Audra Causey was the only one who had the authority to terminate the plaintiff, and we know that she was there at the store the day that termination was entered. The other case cited by plaintiff on this adverse inference issue was International Union. And the court there said the rule is that when a party has relevant evidence within its control, which he fails to produce, that failure can give rise to an inference. So there has to be evidence that we are withholding, that we've destroyed, that somehow we're keeping to ourselves before the adverse inference rule comes in. Your Honor, you asked earlier about the hostile work environment claim. And so I wanted to address that as well.
Yeah, thank you. I heard all of this and tried to point the council to that direction. I never got to it. And I'll give you at least where I'm coming from so we don't have to go round and round about it. You know there are 4 elements for this hostile work claim. The court and you only focus on the 3rd one, of course, probably rightfully so. You know, the 3 are pretty much there. And that is whether this conduct was severe and pervasive conduct. The question here that's really the focus of this case, and I'm not sure squarely set up by the 4th Circuit or where it is, but the question is, you have her testimony and you have her deposition. I could go through the litany of things she has in there, but I don't need to do that. We can just assume that it's a lot there. The basis the court relied upon was saying it lacked corroborating evidence. And my question and my concern is, typically in cases in which you do have testimonies of individuals who, in this instance, I'll call it a victim, for want of a better way to describe it, she may or may not be one, gives testimony that could establish the element of hostile work environment. Is there a differentiation between self-serving opinions and testimony that gives personal knowledge of the acts? You know, the 9th Circuit has held such, and there have been other cases to hold such. I don't think we've directly addressed that question, but it seems to me that an individual who gives testimony that's on personal knowledge of acts, not of whether it was whatever a personal opinion, self-serving opinion, which clearly I think you're going to need something corroborating to go with that. Is that a differentiation? And I'd like for you to speak to that, because that's the issue in this case. I think that's keen and the one that presents us something to decide.
Yes, Your Honor. So our position is not that a plaintiff's testimony is always going to be self-serving. It is not that a plaintiff's self-serving affidavit can never be enough to get to summary judgment. In this particular case, we say that it is not. We cited the two cases in.
So let me make sure we are on the point with that. So therefore, you're saying this affidavit and the deposition may be sufficient if the evidence in it that she says would be sufficient to establish hostile work, then it would be enough to get it to the next step.
If she brought forth
So you're-
enough
in other words, you're not saying things beyond the opinions require corroborating evidence.
No, Your Honor, I think there's case law that does establish that in a situation like this, especially where there is conflicting testimony, and that's the Nigro case that was cited, and that may be the one that you're referring to. In that Ninth Circuit case, the court said, if the plaintiff comes forward with facts, we're going to let that go to a jury.
Says if it's based on personal knowledge, legally relevant, and internally consistent. I guess that's the part you're dealing with.
That's the part that I'm addressing now. So the internally consistent. And in this.
But what does that mean? Internally consistent with what she is saying, or internally consistent with what the case? That doesn't sound like that's what they're talking about.
No,
Seems like they're talking about what she is saying.
Correct, and I think that's exactly what they're saying. And that's a problem in this case, because the plaintiff has been basically all over the place with all of the important facts. You know, I'll give you the example of what happened in that 2-week period in January before her termination. She first said that she did not show up for those shifts on January 1st because she came down with COVID on January 1st. Then she said she came down with COVID on January 11th. She's also said that she never saw a schedule for those 2 weeks, but then in other testimony said, well, when she caught wind of the schedule, she had to be off.
Help me on that. I'm talking about the hostile work environment, which are these specific things. I'm talking about her establishing in that hostile work, whether she came to work or not, I understand that. Okay. It could be bad all day long. But when she got to work, this is what she said. She said, he's approaching her all the time asking for sex. He wants to take her home to go to sex. He's asking, when are you going to stop playing with me? He goes, there's a whole litany. It goes on about being, the jealous part may be an opinion, but the rest of it goes on, puts on the speakerphone, talks about this vulgar conversation, propositions for her for sex several times, threatens to terminate her. You know, that might be an opinion, I don't know, but I'm dealing with the specific acts of hostile work environment. Then she goes on in the deposition, and then he said, he asked me if he can come back to my place and possibly have sex, I guess, and a number of things about a certain, offered her a ride and claimed that that he's called her a third time about all these things here. I'm not talking about what time she got to work.
Okay.
The other aspects, I don't think it's relevant to, maybe, if you, but you tell me, how's that relevant to a hostile working environment based upon someone who is, based on her testimony, consistently harassing this young lady for sex and over and wants to take her home and making all these gestures and stuff to her. That's what I'm getting at.
Okay.
If that's her testimony, and the court said it's not corroborated, but you've agreed, at least I understand, that doesn't have to be corroborated. It can be, but you think it's insufficient to be pervasive and severe. Is that right?
Let me restate and make sure we're on the same page.
Right.
I believe that in this I believe there are situations where uncorroborated testimony is enough. This is not one of those situations. And so if we're looking only at the issues arising in the hostile workplace, her story did change over time with that as well. So when we first hear about what her claims are regarding Mr. Edwards, it was that on her first day of work, did she need a ride home? What's she doing after work? And do you want to go back to my place? There's no link then about any sort of demand for sex. That doesn't come until later in deposition testimony. So there is some changing story there.
It's not a change. That's just something that she said earlier. But the evidence the only evidence I see they have to support this is her testimony, and during the discovery, and then the deposition that's here. Those are the two pieces of evidence I'm focusing. What she said outside, that's not inconsistent, she just didn't mention it. But here she's mentioning it.
Well, and that's where the Freeman and the Holly cases come in. And those are district court cases in the Fourth Circuit. They both cite to Evans, a Fourth Circuit case. Both of those cases, for example, Freeman deals with a sexual harassment situation between a supervisor and an employee. So in that case, the employee gave some specific examples, like Ms. Crouch did in this situation, about how there had been staring, there had been some unwanted touching, there had been comments that had been made, and then there was something that happened in New York at a conference or some sort of offsite. And then she did, the employee who was male did generally state that I was touched 2 to 3 times a day. And so in the Holly court, they noted mere assertions by the plaintiff are not sufficient to survive summary judgment. And one of the reasons there is that this individual testified that there were coworkers who had observed this, there were friends that had observed this.
That goes back to the corroborating aspect of it.
Correct.
The court says mere assertions by the plaintiff. I'm not sure we've ever said that. There are cases that deal with if it's opinions, if you're given a self-serving statements on opinions. But she, in that case, was testifying about specific acts that occurred. All of them. And those cases are hard to determine anyway. I mean, sexual harassment, who goes around letting everybody see what you do? I mean, if you're dealing with a supervisor and employee situation, they don't do that kind of a thing. It's done on a one-on-one, back and forth. And what corroborated? You don't have witnesses that hear these things, or maybe evidence that he wrote. Maybe if you can get something they wrote, someone that dumb, then you really got something going on. But most of it is going to be oral type conversation.
That can be true, but in this case, we have testimony that she told her friends about these requests for a ride and I want to have sex with you.
But that shouldn't defeat it, because there's some others who can corroborate what she has. If her statement is sufficient in and of itself, the failure to then further prove it up by corroborate can't defeat evidence. It doesn't make it inadmissible evidence, because again, if her statements are sufficient, then the fact that somebody else knows and you didn't tell that somebody else knows, I mean, that's a weighing. I don't know what it is. Maybe
I think
it's credibility.
the point, Your Honor, is that her testimony alone is not sufficient in this case. And again, what the Holly court said, quoting Evans, was the absence of objective corroboration of any kind of plaintiff's self-serving testimony.
But Holly was a district court case, right?
It was, Your Honor.
So you
Again,
know
but they're quoting
that's not
Evans
very
here.
helpful in terms of us when we're talking precedent. I mean, maybe it's not even persuasive from my perspective, but I get some courts said that. And I agree.
But
But you can say it, and you will get as much force with that as that district court said it.
Well, they are quoting a Fourth Circuit case, though, for this proposition.
Well, then tell me about the Fourth Circuit case. If the Fourth Circuit case says it, then you got it.
Well, what the Fourth Circuit says is absence of objective corroboration of any kind of self-serving testimony, a plaintiff's self-serving testimony, makes it unlikely that plaintiff has raised a material issue of fact.
And that goes to the instances in which a self-serving testimony is about opinions and matters are there. It does not specifically address where there are personal eyewitness knowledge of something. And I don't know, a lot of cases, we don't require that now. Eyewitness knowledge, you saw it. We don't need to we got you. That's evidence, it's admissible. Then you go to the weight of it and everything else.
The Evans court also said, however, Your Honor, that unsubstantiated allegations and bald assertions will not carry the day. I mean, these are unsubstantiated allegations. She is alleging that this employer, the supervisor, did X, Y, and Z. But she's not bringing in any of the other people that she says.
I'll turn it loose, but I will say sexual harassment cases are very difficult in these environments here, because nearly all the things that are going to be said are going to be said in a context where it's going to be just one-on-one, and one can easily say that's unsubstantiated. But I don't think that's what's intended here with the hostile work environment. The other claims in there, I'm tending to see where you go with that. But that one, I think it really comes down to the evidence that she presents, whether it is admissible, and if so, is it sufficient, which is where you've gone on this, and I appreciate that.
Thank you, Your Honor. The last thing that I would really touch on is the idea of the second tier of the McDonnell-Douglas burden shifting test, because while it does not apply to the sexual harassment, hostile workplace claim, it does apply to the other Title VII claims, as well as the retaliation claim under the Fair Labor Standards Act. And our point there is simply that if a prima facie case had been made, which obviously we don't agree, but if a prima facie case had been made, the question then is whether we have produced a legitimate, non-discriminatory reason for the termination. We believe we have. This is a burden of production. It's not a burden of persuasion. We said who could fire her. We said when she was fired. We gave history of her absences. And at that point, if we have offered reasons for our action, which if a jury would believe that, would support a finding that unlawful discrimination was not the cause of termination. It then shifts to the plaintiff. The plaintiff has to come forward with something to say that our reason for termination was pretext. She has not done this here. The most that she's really said is that when she worked at that location a couple of years before for a different franchisor, so different employer, that at that location, the hostesses clocked in and out. I'm sorry, that goes to the retaliation claim for Fair Labor Standards Act. But my point is she's not come forward with anything to say that the reason for that termination was pretext, which is her burden. Your Honor, we believe that Your Honors, we believe that the decision of the trial court should be affirmed.
All right, thank you. All right, yes, in rebuttal, Mr. Fong?
Your Honor, I want to start by citing the Wanamaker Amos, which this court just put out this year. It says that it's not the job of the court to weed out weak cases. It's not the job of the court to substitute its judgment for the role of the jury. That's precisely what Judge Wynn was talking about when the plaintiff testifies to facts, to things that have actually happened to her. The defendant can then offer whatever it wants to say, no, that didn't happen. But the fact that plaintiff testified to specific things that happened to her, those are facts that a jury has to weigh who to believe.
Is it different in a sexual environment, a hostile work environment, than in typically other instances because of the nature of the offense? And I'm thinking that in a hostile work environment, one who is harassing would typically, if very careful about it, would go to extreme means not to do something like this in front of anyone else or to present it. So it makes it a very difficult thing. But you know, elements include the severity. It's very severe and pervasive. And so as it indicate that, you know, it's not a one-off where you just sort of ask one or two times or you just make some suggestive statements. I mean, it makes it difficult. So you need something more than that. You need something, even in her testimony, to indicate that this is continual. And there are instances where it's been continual, and yet maybe no one else heard it but the two of them, or maybe it wasn't presented to anyone but her. And that could be even with the touching or anything. There was no touching here that I picked up. She didn't testify to any touching.
No, she didn't testify to any touching.
Okay.
But I think we're in agreement, Your Honor, that she testified that this happened multiple times. He requested for her to either to go to her house or to come back to his house and have sex with him.
See, that's key, is what did she testify? How many times and how much did it happen? That's key, is how much is there in her testimony to satisfy that third element.
I think in her deposition, she said almost every time she worked with him. I also think that the severity, because severity and pervasiveness are, the more severe it is, the less often it has to happen. The severity of the phone call, of him playing that phone call for her, I think meets by itself the hostile work environment claim. And I think that you're onto something, that because of what sexual harassment is, and it is something that happens between two people, usually out of sight, that the court needs to let a jury hear what happened from the mouth, especially of the victim.
But we don't want everybody who has a complaint against a supervisor to come in and say things directly. That's the thin line. It could be made up. You understand what I'm saying? It could be. And it would create a court case every time someone comes in and present that. So it seems like it needs to be something there. Even something more than that, even though I agree, I tend to believe that personal acts would be something you can testify to. The question in this type of case, what does it mean? In other words, to use a term from one of my colleagues often, is what is the limiting principle to this type of action here?
Well, Your Honor, I believe it's testimony from personal knowledge. I am of the belief that it is for the jury to decide who is telling the truth and who's not, and that's not what the court's supposed to do. Especially when it comes to these kinds of situations when it's going to be he said and she said.
I don't think it's an admissibility issue. I think it's a question of whether it provides a sufficient opposition for a question of fact, even though it is admitted. And the logic behind the general principle is that if the evidence is presented in a context, in two different contexts, one in the context where other people witnessed it and saw it or were told about it, they should be brought to corroborate it, or where the deposition says one thing and the affidavit says something else. But we've gone over those principles, and I don't think it's questions whether that applies here. All right, well, thank you. I'm sorry that I almost cut out your argument for today, but we appreciate the arguments.